All right, it is 9 a.m. on Friday, June 4th, 2021. This doesn't sound on. Oh, it is Friday, June 4th, 9 a.m. If I could have counsel for the parties, please put your appearance on record.
Taylor May on behalf of the Office of the State Attorney.
Tyler Brands on behalf of the Office of Public Defender.
Richard Millian, counsel for James Tyree.
Are we bringing his client in soon, Dexter?
Yes, you are.
Okay, perfect.
Thank you.
We have a video? All right. Let's see if this works. Do they know to come at 9? Okay.
Welcome to an Econo meeting. You are entering the meeting now.
I don't see any attorneys on there. Oh, it just changed. There we go. Counselor, can you hear me? Your video is freezing. Oh, she's going to try again. Well, it's already an adventurous Friday. Good morning. Please tell me your name. Sarah Scott. All right, we're trying to get connected to your attorney right now. Counselor, can you hear me now?
Yes, Your Honor. This is Attorney Ginger Miranda.
All right, excellent. We can hear you as well. Are you here representing Sarah Scott?
Yes, Your Honor.
All right, this is 21 MM 108 AE. Ms. Scott, you've been charged with violation of a pretrial release condition on a domestic violence case. There is probable cause in this case. Ms. Scott, did you wish to, I'm sorry, not Ms. Scott. Ms. Miranda, did you wish to be heard on anything in this case?
Yes, Your Honor. We are asking the court to set a bond on this motion, on this charge. Obviously, there was a misunderstanding. We didn't represent the original charge, Your Honor. Just took the case today, and so we are asking that you set a bond on this charge.
What says the state?
Your Honor, I have no objection. Generally, when we do a no contact order, we tell the defendants that if the victim's not there, they can return. So the state has no objection to you setting a bond.
So, Ms. Scott, you saw me the other day in court, and I ordered you to maintain a separate residence and not have any contact with the victim. And you said that you were returning to New Mexico, that you wouldn't be going back to this house and you'd be returning to New Mexico, and I authorized you to return. I also authorized a one-time return with law enforcement to gather your belongings. So you were in court and I was in court, and I recall ordering all of those things. Counselor, I understand you didn't represent her at the time, but the court's order
Yes, Your
was
Honor.
very clear.
Yes, Your Honor. And I believe I'm going to get something for the state on this, but I believe that there was something given to her about, or something told to her about him leaving to North Carolina, I believe. And so she was under the belief that he was not at the home, and she was led to believe, and erroneously, obviously, Judge, because you clearly explained it, but that she could return to get her things based on him not being there.
I did order that she could return to gather her belongings with law enforcement. Law enforcement was not with her.
Understood, Your Honor. That's why I'm saying the misunderstanding happened because she was told that he was not there. That's why she thought law enforcement had to be present if he was there.
I don't really think that's reasonable, Ms. Scott. You were in court, you heard the court's order.
And Your Honor, now that she is represented, we will go over all of the conditions with her and make sure she is in compliance with all of the court's orders.
All right, at this time in 21 MM 108, your bond will be $1,000 with all of the same conditions. You are not allowed to have any contact with the victim. You must maintain a separate residence. I'll allow a one-time return with law enforcement officers. Is there anything about my orders that you're unclear about this morning, Ms. Scott?
No, ma'am.
You're not allowed to possess a weapon of any kind, firearm or ammunition. At this time, Ms. Miranda, I'm inclined to revoke her bond in the battery case unless you can give this court a reason not to.
Your Honor, again, she was
Counselor, you're frozen. Oh, I think we lost her.
having,
Oh,
Judge,
yes, okay, try one more time.
you missed all of that wonderful oration. I don't know if I can repeat it.
I'm sure you were waxing eloquent. I'll give you credit for that, but we didn't hear any of it, I'm sorry.
Okay, Judge, I'll try again. Judge, I was just saying that now that she's represented for the underlying battery charge, I will assure that she understands all of the court's conditions and abides by all of the court's conditions. I do believe this case was a misunderstanding, and we do ask that you not revoke her bond on the underlying battery count.
Ms. Scott, based on your attorney's arguments this morning, I will not revoke that bond, but I want to be sure that you understand very clearly this morning that if I see you again for violating my release conditions, I will hold you at no bond. Do you understand that?
Yes, ma'am.
Is there anything that you need to ask me about these conditions? Or are you clear on what I'm ordering?
I'm clear on what you're ordering.
All right, good luck, ma'am. Thank you, counselor.
Thank you, Judge. Have a great day, everyone.
You as well. Oh, that's this one. All right. Is James Tyree next?
Yes, Your Honor.
All right. Mr. Herman, are you here on a case that's scheduled for the afternoon?
I am, but it's domestic, so I'm not sure why it was, but he's there, he's here.
All right, I don't have that probable cause affidavit. If you want to walk down the hall to the JA and ask her to bring it to me, I'm happy to review it and I'll hear your case this morning.
Deal. Thank you, Judge, I can do that.
Right, but I don't have it because she didn't have it this morning. But I don't know if she has it now.
Thank you, I'll be right back.
Yes, sir, I just want to make sure you understand. I haven't reviewed it yet.
Taking me out of order, I appreciate it.
Put it down like this so you can breathe a little better, okay?
Good morning.
Sir, please tell me your name. This is 21MM 3793. Counsel, would you like to put your appearance on record?
Yes, Your Honor, my name is Richard Millian. I'm counsel for Mr. Tyree.
All right. Sir, you're here charged with battery domestic violence. I reviewed the probable cause affidavit. There is probable cause in this case. I see that I have two witnesses here. Did you want to testify this morning?
Yes.
You do? Okay, I need you to raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God? Yes. Please state your name for the record. James Hauser.
All right, you can put your hand down, sir. Thank you. I'm going to let the prosecutor ask you some questions.
Yes, ma'am.
Good morning, sir. Can you please state your relationship to Mr. Tyree?
Grandson, grandfather.
Are you afraid of him?
Not really, but
As this case is going on, do you want to have contact with him?
yes,
Okay. Has anything like this ever happened before?
not before, but it just recently started.
Okay. Has this been the only incident that's happened?
There's been 3 times he did it, and I told the school about it.
Okay, so 3 times?
Yes,
All right, thank you. If anything like this ever happened again, would you feel comfortable telling someone or calling 911?
yes.
All right, thank you. That's all I have, Your Honor.
All right, thank you. Defense, would you like to inquire?
No, I don't want to inquire, Your Honor.
All right, I think you need to get closer to a microphone because I'm not sure we'll pick up your comments and arguments.
Your Honor, no, I have no questions for the witness.
All right, thank you. Thank you, sir. You can stay right there. Did you wish to testify, sir?
I am Jimmy Hauser's uncle. I am Robert Reardon, the husband of his Aunt Kimberly.
Hold on. If you want to testify, I need to have you sworn in.
I am not testifying. I wasn't there for it. I'm just here because of his
Okay.
personal issues.
Okay, all right, great. Thank you for being here.
You're welcome, ma'am. Thank you, Your Honor. And I apologize for my shirt. I was not planning to be here.
It's all right. No apology needed, but thank you for being aware. All right. Did the defense have any argument to make as to bond?
Yes, Your Honor. My name is Richard Millian. I am a civil attorney, and my secretary is Debbie Tyree. She has been my secretary for 20 years. The defendant is her husband, and that's why I'm here this morning. So the defendant and my secretary have been guardians for the defendant since he was an infant for probably 15, almost 18 years, and they have raised him. Lately, there have been some family tension because of behavioral issues, and that led to the incident last night. My client has no criminal record. He is a veteran. The other thing I want the court to know is he's twice had cancer, and they believe his cancer is back, and he has an appointment with an oncologist on Tuesday. So because of all that, we're asking the court to release him on his own recognizance, or at the very least, a very minimal bond with whatever restrictions the court feels is appropriate after listening to the witness.
Thank you. What says the state?
Your Honor, I believe Mr. Tyree otherwise qualifies for PTR. Given the victim's living situation, I don't know if it would be prudent to place him on PTR, given the separate residences, one-time return condition that's generally ordered by this court. But if he otherwise qualifies for PTR and the living situation for Mr. Hauser would be safe, state has no objection to PTR, given he has a very limited or no criminal history.
Your Honor, if I might.
Yes.
We understand that the tension may require the defendant and the witness to be separate for a little bit. And so we have arranged for Mr. Tyree to go stay with his sister for a cooling off period and to get through his oncologist appointment on Tuesday. So if the court feels that's appropriate, the defendant has no objection to that.
All right, at this time, Mr. Tyree, thank you, everyone. I'm going to place you on pretrial release with special conditions that you can only have peaceful contact with your grandson. Do you understand what peaceful contact means?
Yes, Your Honor.
No hostile contact. You're not allowed to possess a weapon of any kind, firearm, or ammunition. At this time, I'll order you to maintain a separate residence and allow a one-time return with law enforcement to gather your belongings. And Counselor, just so you're aware, if the living situation changes or if it's able to be worked out separately, if you file a motion in front of the trial judge, they can change that order, and then he'll be able to return to the home.
Perfect, thank
You
you.
just can't right now. So you understand that, Mr. Tyree? All right. I didn't see any alcohol alleged in this incident. Did you, Ms. May?
No, Your Honor.
Any other conditions the state would request then?
Not at this time.
All right, good luck, sir. Thank you for your service to our country. I hope your appointment goes well on Tuesday. Thank you, Counselor.
Thank you for your help.
Yes, sir. Thank you for coming, gentlemen. I appreciate it.
Okay. Who we have next, Your Honor?
Next, I have Renee Vaughn. But we got another attorney here, so I don't know who his client is. We got all kinds of stuff.
Do you know what section Ms. Vaughn is from?
Domestic, misdemeanor, domestic.
Thank you.
Please tell me your name.
Renee Vaughn.
I'm sorry, one more time?
Renee Vaughn.
You have to leave your mask on. This is 21MM3807. You're here charged with battery, domestic violence, and resisting an officer without violence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Sir, do you wish to testify?
Yes.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Nico Mitchell, and my last name is MTTCHELL.
I'm going to let the state ask you some questions.
Good morning, Mr. Mitchell. Can you please state your relationship to Ms. Vaughn?
My girlfriend.
Okay, approximately how long have you known her?
Off and on for about 5 years.
I can't hear you, sir. Could you get closer to the
Off and
mic?
on for about 5 years.
Okay, thank you.
Are you afraid of her?
No.
Do you want to have contact with her?
As long as there's no alcohol or anything like that.
Okay.
I can't hear him.
He said as long as there's no alcohol or anything like that.
I see.
That was going to be one of my questions to you, is do you believe alcohol or drugs played a part in this incident?
It wasn't no drugs, but alcohol did play a big part in this incident.
Okay. And has anything like this ever happened before?
Not on this nature, no.
Okay, thank you. That's all I have, Your Honor.
Does the defense wish to inquire?
No questions, Your Honor.
All right, thank you.
She does otherwise qualify for PTO, though. She's been unemployed for the last week. If PTR is sufficient, I don't see a necessity for a monetary bond, but it is in your discretion, Your Honor.
All right, at this time, ma'am, I'm going to place you on pretrial release with special conditions. At this time, I'm going to order that you not have any contact with the victim. Do you understand what no contact means? You have to answer out loud.
Yes, I'm sorry.
All right. You're not allowed to possess a weapon of any kind, firearm, or ammunition. I'll order you must maintain a separate residence. I'll allow one-time return with law enforcement to gather belongings, but you can't coordinate that through him. You do that through law enforcement. You understand? I'll order that you're not allowed to possess or consume alcohol, and you'll be subject to random alcohol screens while on pretrial release. Anything else from the state?
No, Your Honor.
Yes.
But I thought if he said he's not afraid of me and it's my first time and I never got in trouble before.
I understand. The reason I'm ordering no contact is just after reading the facts of the incident, it seems like maybe a period of cooling off, maybe not talking to each other for a little bit might be good for both of you.
How long is that? Because I live in the residence.
So that lasts until another judge changes my order. So your attorney can file a motion in front of the trial judge and ask that judge to change the order. So if you live together, you can go back and gather your belongings with law enforcement, and then you have to go somewhere else for a time.
Can I ask another question?
Yes, get close to the mic. I want to make sure I can hear you.
Who do I talk to about that? I don't know anything.
The Public Defender's Office is representing you.
You can ask for it from the court. I can't give it to you legally. I can't give it to you. It's not filed off, and you're not entitled to it.
Does the state object to peaceful contact?
Am I allowed to say anything on this?
Hold on. Yes, let me ask the state. After reading the facts,
It seemed like a rather violent incident and went on for a significant period of time regarding battering the victim as well as other items within the home.
right.
I believe this is the one where she punched the window or broke the window, and that led to the cut on her
Things.
arm. If the victim wants no hostile contact, state will object, Your Honor.
All right, sir, what did you wish to say?
I don't mind her. I just don't want her to be having no alcohol and at all whatsoever. I'm not scared as long as she can have no alcohol in her system. I believe she can think rationally and she can be around me.
Your Honor, may I ask him another question?
Yes.
Do you mind if she returns back to the shared residence?
No, not at all. As long as there's no alcohol, she anger management possibly, but no alcohol.
Do you believe the court ordering that she's not allowed to have alcohol and ordering that she have random alcohol tests, do you believe that will keep her from drinking alcohol, or are you concerned that she may still?
If that's the process, I just don't want this, like, if there's no alcohol, if it can just be standstill, there's no alcohol, if the court can order no alcohol or anything like that, I would appreciate that, but I don't fear for her, I just don't want her to drink no alcohol. That's my only issue.
All right, I'm going to change my order and allow peaceful contact, and I'll also allow you to return to the residence. Ma'am, do you understand what peaceful contact means?
Yes, ma'am.
So don't even raise your voice. You can't throw things, you can't hit him, you can't yell at him, just peaceful contact. You understand?
Yes.
And you will be subject to random alcohol screens, and you can't drink at all. You understand that?
In the
Is
condition
that
of,
forever?
I'm sorry, what?
Is that forever or?
That's until another court modifies my order. So for the foreseeable future, you can't drink alcohol.
Okay.
All right,
Your Honor, in the condition of no weapons, firearms, or ammunition stands.
of course. You still can't possess a weapon, firearm, or ammunition. All right, good luck, ma'am. Thank you for coming, sir. Good luck. Wait, who's that?
Mr. Pena, who you haven't read yet, probably.
Yeah, I haven't read that one, so we can do it, but you're gonna have to give me a minute to read.
Your Honor, it's a very short warrant.
Okay, this is 21 CF 6295. Sir, please tell me your name. Coming up to the mic.
Carlos Pena?
All right, and counsel, you want to put your appearance on the record?
Yes, Your Honor. Attorney Scott Herman on behalf of Mr. Pena. If I could approach the clerk with my notice of appearance again?
Yes, please.
Judge's ruling, probable cause affidavit.
All right, sir. A warrant was issued for your arrest, charging you with aggravated battery with a firearm. Another judge has already found probable cause. What degree felony is this?
It's an F2, Your Honor.
Yep.
All right. Mr. Herman, did you wish to be heard as to bond?
Yes, Judge, he does have significant ties to the community. Mr. Pena has no prior criminal history. He's a graduate of University High School. He is 20 years old. If released, he would reside with his father at 5962 Tivoli Gardens Boulevard in Orlando, Florida, not with the alleged victim in this case. As I stated, he has ties to the community, is not a flight risk, has no prior criminal history, and it is a second-degree felony. So we are asking court set a monetary bond in line with, is the bond schedule 10? For that?
I'm sorry,
Is
what?
the bond schedule 10,000 for that?
I think it is.
I believe that's,
What says the state?
Your Honor, he is entitled to a bond as it is an F2. State would just ask that you set a reasonable bond. The state's concern is the thought process of Mr. Pena. It looks like the victim, the argument was done, the victim was trying to walk back into the apartment, and that's when he reached into his car, retrieved the firearm, and shot at her allegedly 4 times, only luckily striking her once in the heel. So the state's main concern is the thought process. The argument seemed to be done when he then retrieved a firearm and discharged it at her as she was walking back into the apartment. So I just ask that you set a reasonable bond. I understand he has, I believe, very little, if none, criminal or no criminal history.
I see no criminal history.
Yes, Your Honor. So I just ask that you set a reasonable bond, taking into account what seems to be his thought process.
just the only thing I'll add is the victim, the alleged victim, has a lengthy prior criminal history, including violent offenses like armed carjacking on her record. But regardless, Judge, he is entitled to a bond. We were asking for 10, whatever the court feels is appropriate. As I stated, he's local, he's not going anywhere, and obviously, I'm sure the court will order no contact, which he will agree to. No firearms he will agree to, whatever the court feels additionally is necessary.
Your Honor, respectfully, the victim's criminal history is not at issue here today. The credibility is not at issue. The warrant is mostly seen through a third party who witnessed the entire incident.
All right, at this time, sir, your bond will be $10,000. You're not allowed to have any contact with the victim. Do you understand what no contact means? You can't contact her on social media, send a message through friends or family, nothing. You understand? I'll order that you are not allowed to possess a weapon of any kind, firearm, or ammunition. I'll give you 24 hours from your release to surrender this firearm to the sheriff's office. Do you understand that?
Judge, I'm afraid he doesn't know where the firearm is the problem. Hold on, one moment. Judge, he's informed me he does not know where it is.
You should check your car. Because according to the warrant, the eyewitness saw you get back into your car and leave.
Judge, I don't want him to speak to the facts of the case. This happened 7 days ago, approximately 7 days ago, and he was arrested 7 days later. Hold on one second.
Counselor, I can't let him leave without ordering that he surrender that firearm. I understand you're telling me he says he doesn't know where it is, but if it's in his car and he gets out and shoots the victim, I don't know what to say. Do you have an idea?
I don't want my client to address this.
I understand.
Okay, but I don't think he has the ability to reobtain the firearm. I think hypothetically it might have been, it's gone.
Do you have any other firearms in your possession?
None.
I don't mean right now, obviously, you're in jail. I mean, at your house.
None at home. No, I don't have it.
Okay. What says the state?
Your Honor, I'll leave it within your discretion.
If it's a physical impossibility, I don't want him to violate a court order for that. So I'm going to strike that from my orders. But I will leave the order that you're not allowed to possess a weapon of any kind, firearm, or ammunition.
Perfect.
So whether you reacquire that one or another one, that will violate this court's order. You understand?
I understand.
All right. You're not allowed to be within 500 feet of the victim's residence or place of employment. Do you understand that? And you're also not allowed to have any contact with
There's an eyewitness.
Axel Montalvo.
Is that okay?
You understand?
Yeah.
All right. Are there any other conditions the state would request?
No, Your Honor.
All right. Good luck, sir. Thank you,
Judge.
Counselor. The must surrender that firearm. I'm striking that, but still no weapons. All right. Well. Good. How are you, Counselor? Come on up. Yes. Yes. Come on up. What case are you here on? Okay, I haven't read that one either. Right. Is that her? Yes. Okay, let me read this really quickly. Ma'am, tell me your name.
Tisha Rosa.
All right.
Yeah, that don't look like a police.
All right, this is 21 CF 6521. A warrant was, hold on, Counselor, go ahead, put your appearance on record.
Good morning, Your Honor. Harold Thompson on behalf of Ms. Katisha Rosa.
All right, a warrant was issued for your arrest, charging you with trafficking in oxycodone greater than 28 grams, conspiracy to traffic in MDMA greater than 10 grams, possession of a controlled substance with the intent to sell, possession of alprazolam with intent to sell, possession of cannabis with intent to sell, possession of tetrahydrocannabinols, and possession of drug paraphernalia. Another judge has already found probable cause in this case and set bond for all counts. Counselor, did you wish to be heard as to bond?
Yes, Your Honor. I just would like to ask the court to entertain a reduction in the bond amount as to counts 1 and 2. I believe that's a little excessive under the circumstances. She has no prior criminal history. She has substantial ties to the community, has a 12-year-old son. She has no intent to flee from prosecution in this case. She's not a threat to the community. We will argue that as well. But however, I understand the severity of the charges. We just ask if you would consider reducing the bond to something more reasonable or something she can actually obtain?
All right, Counselor,
Your Honor.
I might consider that, but I also have to advise you that I have a record that she's out on bond for possession of cannabis with intent to sell or distribute and possession of cannabis greater than 20 grams.
That's correct, Your Honor. And this stemming from the same situation. See what happened
Okay.
with some traffic stop that happened on a particular day. And then based on that traffic stop, officers went to her house and executed a warrant. Some things were located in the home allegedly. And then this warrant stemmed from it. It all relates back to that particular case. So I believe eventually it'll all be consolidated into one thing because all of this is stemming from that initial arrest that she was out on bond for. I don't know why.
All right, because I'm inclined to revoke that bond,
Right.
but
Your Honor, respectfully, it's two incidences. If she was stopped for a traffic stop and they found this amount of drugs on her, so they then executed a search warrant under the assumption that she most likely had a lot of drugs in her house as well, and a judge signed that warrant. Respectfully, it's two incidences. She didn't have all the drugs in one particular place, which is generally when we would consolidate if all the drugs are in a particular place. So respectfully, it's two incidences. As to bonds on the trafficking conspiracy to traffic, the intent to sell case that she's before court for today, another judge has already found PC for that and set the bonds that they determined to be reasonable. So I ask that you stay those bonds. The amount of drugs that were located was significant. The oxycodone was, I believe, well over 28 grams, which in and of itself is very costly. So I believe the bonds that are currently set are appropriate, given that she had drugs located in a vehicle and located in her house.
Your Honor, may I be heard briefly on that?
hold on one second. So let me I didn't have this before court, so I'm reading the affidavit while we're sitting here. And it looks like it stemmed from a complaint to the crime line that someone named Rosa, who matches your client's description, was dealing drugs out of a house. So it came from that.
Right.
Then the traffic stop, and then the warrant.
Yeah, so what happened, Your Honor, at the traffic stop, she, and I don't have anything that you have in front of you, but I have some knowledge about what happened from interviewing witnesses.
Okay.
When she was stopped at a traffic stop some distance away from the home, officers they detained her, kept her for several hours. They went to her house without a warrant at that time, knocked on her door. It was two people there already, one individual by the name of Jonathan Carrillo and her son, her 12-year-old son, okay? And they pulled him out of the house, I believe allegedly, they may say they did a protective sweep, but they had no reason to go in the house. But they had him outside for several hours. Then they got a warrant, but they had already searched the house. And my understanding, they recovered some controlled substances. Then she was not charged for those substances on that particular day. She was only charged with what was allegedly found on her in the traffic stop. But these current charges, from my understanding, is stemming from the search warrant that happened on that home, but they did not charge her at that time. Now they're just circling back and charging her with everything all at one time. So I don't believe it's two separate instances.
All right, so based on that argument, I will not revoke her out-on-bond case. Thank you
Thank you, Your Honor. I appreciate you. I'm sorry.
for explaining that. I agree, I'm not going to revoke that. But as to bond in this case, I need to read a little bit more. So y'all, everybody just give me a minute, sorry.
That time, Your Honor,
I'm trying to multitask here, but in fairness to your client, I need to make sure I read something to make sure I understand it. Oh. All right, I
Your Honor.
was able to read the affidavit. Hold on, go ahead, Counselor.
Again, as I refound in the warrant, the amounts that she was found with, they're well over all of what she is charged with. The oxycodone is over 28 grams. 225 grams were found. She's had a significant amount of drugs. I think the bonds are reasonable. From defense counsel's own argument, she has a 12-year-old son who arguably was in this house as well. further making these bonds reasonable, that there was a child in this house with a witness who said they've seen multiple drug deals in and out of the house, potentially putting the child in danger. I believe all the warrants are reasonable, all the bond amounts are reasonable, and I ask that you stay them.
Your Honor, may I respond briefly?
Yes, go
Her son has
ahead.
been removed from the house by DCF and is in custody of her mother now. And also, I don't know if the state, I would object to him trying to lay opinion testimony as to what the amount of the drugs would be. I don't believe she's qualified to allege how much that substance would be. And she's still close with the presumption of innocence under the circumstances of this case. And as I stated, it was someone else in that home at the time when the officers went in there. So it's not like it's an actual possession. This case is a constructive possession, joint possession, where the state would have to prove actual knowledge of the presence of where these drugs were actually located. From my understanding, it was a police report that should be on file in regards to her ex-boyfriend breaking into her home as well. And she has an injunction on this person. It is believed that this person had stashed some things in her house when he did that. And so, but that's something that we're going to hash out in this, because we believe also he's that person that made that tip, Your Honor.
All right, thank you.
Thank you.
Counselor, I think you have an uphill battle to climb because in the affidavit, it says that basically she sent law enforcement to her house because she was worried about her son being with the guy who was there in her house. So she's claiming that she lived there. Yeah, ma'am, I'm not asking you to say anything. Everything you say is being recorded and could be used against you. He hasn't seen this, so I'm just telling him what's in the affidavit. And all I know is what's here, right? So I have to take the document on the four corners. There could be lots of other things that you're going to discuss with your attorney. But I'm not going to reduce count one based on the amount, and I do think that's reasonable. I'll reduce count two. So count one will be $100,000. Count two will be 50. Counts 3, 4, 5, and 6, I'll stay at 5,000, and count 7 will be 100. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand? You have to answer out loud. You're not allowed to possess a weapon of any kind, firearm or ammunition. You're not allowed to have any contact with, what's the name of the guy who was at the house, State?
Jonathan Carrillo.
Is that right? All right, you're not allowed to have any contact with him. I'll order you must comply with any plan set in place by DCF. You're not allowed to have contact with any known drug dealers. Are there any other conditions the state would request?
No, Your Honor.
Good luck, ma'am. You should thank your attorney. He did an excellent job for you already this morning.
Thank you, Your Honor.
Thank you, Counselor.
Thank you so much, Your Honor. May I be excused?
Yes, have a nice day.
Good to see you, Judge.
Is that it? That's all the defense attorneys? For now.
Who's next? Oh, I don't have that motion. Do you have that motion?
Yes, Your Honor.
All right.
I'll wait for him to get here.
I'm gonna be here all day. I'm gonna be here all day. This one's gonna take forever too.
I have a copy.
I'm sorry, who?
Thornton.
Thornton. While we're waiting on that, do you want to do the 33-day motions?
Sure. Would you like me to start?
Yeah, go ahead.
McMonigal, 21 CF 5056. It was filed yesterday. Jenkins Senior, 21 CF. Are they out
Yeah, I
of
can't
order?
find that one.
Monagle?
Yeah, I don't have that one. The very first one you said I don't have.
You don't have Mr. McMonigal?
No.
Number 1 on the PD's list.
McMonagle?
These are 33.
Monagle?
Do you have Jenkins Senior?
No?
There should be 11 today. Do you have Harris?
Yes, I have Eugene Harris.
Yes. 21 CF 2773, notice of non-filing. Jamari Jean,
Yes.
21 CF 4366, filed this morning. DeAndre Ross, 21 CF 4684, notice of non-filing. Marcus Harris, 21 CF 5209, notice of non-filing. Dante Lawrence, 21 CF 3973, filed yesterday. Jose Cotto, 21 CF 5020, notice of non-filing. Matthew Clark, 21 CF 2067, notice of non-filing. Edward Wallace, 21 CF 3226, notice of non-filing. Charles Malik, 21 CF 4204, notice of non-filing.
Now I have McGonigal.
Mick Monagle, 21 CF 5056, filed yesterday.
And Jenkins.
Jenkins Senior, 21 CF 4786, notice of non-filing.
All right, thank you. Sir, please tell me your name.
Sonny Thornton.
21 CF 6206. It looks like this was reset for the state to file a motion.
Your Honor, we filed a motion for pre-detention, or a pre-detention motion back in May when Judge Blackman was on the bench. Defense counsel recently got off the case when state this morning filed a motion to continue the pretrial detention hearing for 5 days based on good cause. We already filed a pretrial detention motion. Did you see the motion to continue?
I have no motions.
May I?
Yes, please do. We looked this morning and couldn't find it.
Here is the motion to continue. We filed the motion, it's on the clerk's site, I can print you one if you would like, of the original pretrial detention motion. He was held no bond based off that motion.
I have a copy of the motion here, but do you have a copy of the continuance motion?
I can print another one.
Does the public defender's office still represent him?
No, Your Honor, they filed a.
Motion to withdraw?
withdrew. Yes, Your Honor, they filed to withdraw right after state filed the motion to continue. That's also another one of state's arguments to grant the continuance. He's currently not represented by counsel. This is also not a hearing that he could argue himself.
I believe the defendant, as a friend of the court, Your Honor, the defendant has.
Get closer to the microphone.
As a friend of the court, Your Honor, the rule does allow the defense to offer evidence and present witnesses and cross-examine witnesses during this hearing.
But you don't represent
He
him.
currently doesn't have an
I'm
attorney.
That was my one concern, was I didn't know if he was prepared, but because we don't represent him, I can't instruct him on anything.
Why did the public defender's office withdraw?
I don't know the answer to that.
They don't give a reason?
I don't have the answer to that.
I know a lot of the evidence is under seal, which is the basis of state's motion, is still trying to obtain evidence.
All right, Mr. Thornton. What's happening here today is the state is asking the court to grant a motion to continue pretrial detention for an additional 5 days of you while they continue to conduct some investigation. At this time, you're not represented by the public defender's office because they moved to withdraw, and I'm not sure why. I can't give you that reason.
It was a conflict, Your Honor.
It's a conflict? Okay. I'm going to grant the state's motion and give them an additional 5 days. Hold on one second, yes. And then appoint conflict counsel to represent you because I want to be sure that you have an attorney. Yes, sir, did you have a question?
They already did the 5 days.
Right, it's a motion to continue it another 5 days. I am going to grant the motion, but I'll mark on it that you object.
Been here 8 days though.
I understand. And I guess I can appoint regional conflict counsel. Let's put it on the list because I want to make sure he's represented.
I don't know if that's procedurally how they get appointed. I don't know if you potentially can, I think the PD's office filed the motion to withdraw, if you can just grant that motion to withdraw and it goes to RCC.
Because it should be, if it's for conflict reasons, then it should be in the order.
I think you just need to grant their motion to withdraw.
Usually there's a note, Your Honor, in our system. There's a note that says there's a conflict, and then there's a secondary note. There's not this note here that our regional conflict counsel has been appointed. I don't know if that means that you have to appoint them or if they're automatically appointed because of the conflict, because that was,
Well, they get appointed after the motion withdrawal is granted.
All right, I'm granting this motion. Yes, sir.
how quickly can he get contact with the regional counsel?
I don't know the answer to that. So that is one of the things that I can mark on the order, and I did. Appointment of conflict counsel upon the public defender's office withdrawal. And awaiting unsealing and authorization to disclose confidential, reliable source. So I marked both of those.
Thank you.
So hopefully we'll get you a lawyer as soon as possible, Mr. Thornton. Good luck, sir. Still aren't to our docket yet. Please tell me your name.
Gregory Garner.
I'm sorry?
Gregory Garner.
Okay, that's not who I have.
Gregory Gardner and felony.
Nope,
domestic
he's really far down the list. All right. A warrant was issued for your arrest in 2006 CF 4832 for violating your community control by failing to remain confined to your approved residence except for 1/2 hour before and after approved employment, public service work, or any other special activities as approved. There is no bond authorized on that warrant, and I'll appoint the public defender's office to represent you. In 21 CF 6546, you're here charged with possession of firearm or ammunition by a convicted felon, carrying a concealed firearm, and grand theft of a firearm. There is probable cause in this case, and I'll appoint the public defender's office to represent you in this one as well. I'll stay your bonds at $4,000 on count 1 and $150 on counts 2 and 3. You're not allowed to possess a weapon of any kind, firearm, or ammunition, and you're not allowed to have any contact with the victim. Do you understand?
I don't even know who the victim is.
Shadesha Ingram.
Well, for domestic violence?
No, it alleges that she's the owner of the firearm that was stolen.
Oh, no, I'm saying I don't know who the victim is of the domestic violence.
I'm not there yet.
Okay.
In 21 CF 6426, a warrant was issued for your arrest for battery, domestic violence, and possession of a firearm by a convicted felon. Another judge has already found probable cause. Your bond will be $500 on count 1 and $4,000 on count 2. You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to possess or consume alcohol or any controlled substance without a valid prescription, and you're not allowed to have any contact with the victim, who is Kiara Garner. You understand what no contact means?
Yes, ma'am. So I can't call my own sister?
I'm sorry?
Yes, ma'am, I understand.
All right. Were you two living in the same house?
Yeah, no, I had. Wouldn't have seen him.
All right, because I'm going to order that you must maintain a separate residence. In 21 CF 1539, you have a warrant out of Osceola County for attempted felony murder with a firearm, robbery with a firearm, aggravated battery with a weapon, and grand theft. There is no bond on that case. I'll appoint the public defender's office to represent you, and we'll notify them that you're here. All right, good luck, sir.
Did we do the violation of community control and the VOP?
I don't know, I only have 4.
I have 5.
What's the 5th one? Wait, I can't hear you at all.
And on view for the violation of community.
Where is it? What's the case number?
Same case number.
How can there be 2 warrants on one case number?
One warrant, one on view.
2006 CF 4832 is a violation of probation?
Yes.
But how is that possible with the same case number?
It's an on view. One is a warrant, one is an on view.
All right, you have another violation of probation. And also on your violation of community control, it has several of the violations of failing to remain confined in your residence, so. All right, good luck, sir. Please tell me your name.
Anthony Honor.
21 CF 6510. You're here charged with domestic battery by strangulation. I'm going to appoint the public defender's office to represent you. There is probable cause.
To the probable cause, may it be heard?
Yes.
The arrest affidavit suggests that the alleged victim was only choked. There are no facts that indicate that blood circulation was cut off or airway was cut off. Therefore, I don't think there's probable cause for battery by strangulation, but there is PC in the affidavit at least for battery.
What says the state?
Your Honor, I believe it falls within the battery by strangulation. The victim's testimony is that she was choked. Whether her airway was cut off or the blood circulation was cut off would be a question for the jury at a trial, not for PC purposes.
Your Honor.
Counselor, I think there is probable cause. The affidavit says he began to choke her against her will, and she believed he was trying to kill her. So I find there is probable cause.
Your Honor, I believe officers are instructed to ask the question of whether airway or blood circulation was cut off, as if questions like, were you about to pass out, things like that, and none of that is present here.
I still find probable cause, Counselor. It also says that her neck was red and swollen. That's sufficient for probable cause in this case. Your bond will be $5,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to possess or consume alcoholic beverages or any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
Were you two living together?
We were, but I can always go back to my mom's house, and my name's on the lease, her name's not on the lease, but I'll leave. I won't make it a big deal.
All right, I'm going to order that you must maintain a separate residence, but I'll allow one-time return with law enforcement to gather your belongings.
Is there a way I can maybe get a little bit of AA after I get out of here?
I can't order that, but the trial judge can. So talk to your attorney about that. Maybe there's a program they can get you into.
Okay.
All right, good luck, sir.
Thank you so much.
Yes, sir. Please tell me your name.
Teacher Coward.
In 21 MM 3773, you're here charged with battery. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Your bond will be $500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you live with Terrence Moore?
No.
All right, I'll order that you must maintain a separate residence, not be within 500 feet of his residence. That should be easy. Any other conditions the state would request on this case?
The state would still request the separate residence, Your Honor, even if he doesn't live with them, just to maintain.
I'll order you I did. I said that. And then in 21 CF 6515, you're here charged with aggravated battery domestic violence. I'm going to appoint the public defender's office in this case as well. Counsel, did you wish to be heard?
On the felony case?
Yes.
No, Your Honor.
Okay, I'm just wanted to give you the opportunity. All right, there is probable cause, and I did appoint them. In this case as well, you're not allowed to have any contact with the victim, who is, what is her last name, Counselor?
Dea Tellis?
Yes, you can't have any contact with Khadijah Tellis. Do you understand that? You're not allowed to possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you cannot coordinate that through the victim. Do you understand? Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
How would I get my belongings from?
You're going to coordinate a visit with law enforcement. They'll go with you to the residence, and then you can get your things while they're there with you.
I have to call the police first.
The public defender's office will give you the steps for how to do that. But yes, don't show up without the police.
What was the bond amount on the felony, Your Honor?
Oh, I'm sorry, $5,000.
1,000.
5. All right, good luck, sir. Please tell me your name.
Efraín Ruiz.
21 CF 6562. You're here charged with tampering with a witness to hinder communication to law enforcement, aggravated battery domestic violence, and aggravated assault with a battery. There is probable cause in this case. I'll appoint the public defender's office to represent you.
Your Honor, he otherwise does qualify for PTR. I know there's been a previous case or previous arrest, not a conviction, however.
It's something about that microphone, but I can't hear you guys without it.
It was working the other day.
Is this cell phone close to it?
Right here, can you hear me from here, Your Honor?
I can, I think. Go ahead, counsel.
I was just testing the microphone. Is this better?
What says the state?
Your Honor, since there's been a previous incident between the same victim and the defendant, state would object to PTR. It's showing an ongoing cycle of violence. The violence in this case does also seem to be it was pretty long, seated in her vehicle, pulled her hair, slapped her, hit her thigh with a hammer, threatened to kill her if she called police. It's rather violent. It's hindering her communication to law enforcement, so state fears for the victim's safety as well as the public safety. And given that has been a previous incident, I don't believe PTR is reasonable in this case.
Your Honor, the previous incident was in 2018, and I believe a no contact order should be sufficient, even if Mr. Ruiz is issued PTR. Not about the case. You can ask.
Welcome to the Kano meeting. You are entering the meeting now.
I am going to place you on pretrial release and also require that you post a monetary bond. Your bond will be $5,000 on count 1, $1,000 on count 2, and $150 on count 3. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Never. I don't want to see that woman again.
Do you understand what no contact means?
No, even she don't want it, I don't want to do it.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to return to her residence for any reason. Were you living there?
No more.
Do you have things there that you need to gather?
Yeah, well, I don't want it. I don't want to go back. No, even.
All right, you're not allowed to return to her residence or be within 500 feet of it. Do you understand?
Mm-hmm.
Are there any other conditions the state would request?
No, Your Honor.
All right, thank you, sir. Please tell me your name. 21 CF 6518. You're here charged with aggravated battery domestic violence. I'll appoint the public defender's office to represent you. There is probable cause in this case. Sir, do you wish to testify?
Yes.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Anthony Toledo, Talluto.
State you may inquire.
Good morning, Mr. Toledo. Can you please state your relationship to Mr. Sovich?
He's my boyfriend.
For approximately how long have you known him?
Almost a year.
Has anything like this ever happened before? Was that a no?
No, yes.
Okay, thank you. If you could just answer out loud, because we are recording it.
No.
Thank you. Do you want to have contact with him?
As long as there's no alcohol involved.
And are you afraid of him?
No.
And you mentioned alcohol. Do you believe drugs or alcohol played a part in this incident?
Yes, alcohol definitely did.
And I believe he qualifies for pretrial release, meaning that he could get out of jail without paying a monetary bond. You would just be supervised by the release services. Is that something, does that sound okay to you?
Yes.
Thank you. That's all I have, Your Honor.
No questions,
Defense.
Your Honor.
All right, thank you. Thank you, sir.
He has no criminal history to speak of, Your Honor, as well.
All right, at this time, Mr. Sovich, I'm going to place you on pretrial release. With special conditions, you're not allowed to possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. Do you understand that? You're not allowed to possess a weapon of any kind, firearm, or ammunition. Based on the testimony here today, I will allow you to have peaceful contact only. Do you understand what peaceful contact means? You can't even raise your voice. No hitting, no shoving, no throwing things, no yelling. Peaceful contact only. Understand? Also, based on the testimony, I'll allow you to return to the residence. Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Thank you for coming, sir. Good luck. Please tell me your name. You're here in 21 MM 3804. Charged with violation of a domestic violence injunction. There is probable cause, and I'll appoint the public defender's office to represent you. Counselor, I'm struggling to come up with any conditions of bond that are reasonable that this court can place on your defendant with which he will comply, thereby guaranteeing the safety of the victim in this case as well as the citizens of Orange County. Do you have any ideas?
There's a
Just a moment. And you can say anything you want, but everything you say is being recorded and can be used against you. So that's why I'm asking your attorney.
I believe a monetary bond is sufficient, as well as repeating the circumstances of the no contact order and reinforcing those court orders to Mr. Byrd. And that if he is going to violate those orders again, he is going to be in jail until the trial. That's probably what would happen. So I would have him consider that, as well as the orders that the court issues, and to follow those orders specifically by not returning or having any contact with the alleged victim.
What says the state?
Your Honor, since it's a violation of a DV injunction, you can hold him at no bond for this to get in front of the DV court for them to make a determination. That's what the state's asking you to do at this point. According to the affidavit, there is an allegation of alcohol. The victim stated that she feels powerless. So I'm concerned regarding if Mr. Byrd were to be released on a monetary bond, that the same thing would happen, and that the victim already stated that she feels powerless. So I just asked that you set it no bond so it can be heard in front of the DV court for them to find, they have further resources that this court does not, to help the defendant comply with that no contact and that injunction.
All right, Judge, this is Mr. Caroline Utter, case number 2018 CF 13928, 2018 CF 14800, 2019 CF 1836.
All right, thank you. Good morning, Mr. Utter. And we have counsel, Mr. Mina Long. I'm here, Your Honor. Yes, good morning, sir. Hi, Your Honor.
Your Honor, Mr. Byrd has pointed out in the affidavit that he did get invited. Let's see there.
What I see in the affidavit is that the victim stated sometime later she spoke with Byrd and he began living again with her. And they've been living together for the past year and a half.
Yes. That's why I was suggesting perhaps rereading the no contact order, and that even if she does invite him back, that he still would be in violation of the judicial order.
You are, sir. You have to understand, if a court orders you not to have any contact, it doesn't matter what she says. And the court has no jurisdiction over the victim. The court only has jurisdiction over you. So you may not return to her residence. You may not have contact with her. But another court already told you that, and you did it anyway. And you've been doing it for approximately a year and a half in violation of a court order. That's what concerns this court.
I would still suggest a monetary bond as well, and I believe we've come to the same page as to the terms of the no contact order, Your Honor.
Mr. Byrd, do you understand what no contact means? Do you understand what do not return to her residence means? If this court orders you to do those things, and you don't comply with this order and you come back, I will hold you at no bond. It's likely. Do you understand that? All right, your bond in this case is going to be $5,000. You're not allowed to have any contact with the victim. What are you going to do if the victim calls you on the phone?
Oh, I'm not talking to her.
Do not answer the phone.
Yes, ma'am. I agree with you.
You are not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to be within 1,000 feet of the victim's residence for any reason at all. Do you understand that? Don't make me regret this, Mr. Byrd.
Your Honor, state would also ask for the condition of alcohol.
You're also not allowed to possess or consume alcoholic beverages while on bond.
If Mr. Byrd has any possessions at the alleged victim's residence, does he have any option there, like a one-time return with law enforcement?
No. Your office can file a motion in front of the trial judge. Please tell me your name.
Randall Clark.
21MM3805. You're here charged with violation of a condition of pretrial release and criminal mischief. There is probable cause in this case, and I'll appoint the Public Defender's Office to represent you.
Your Honor, up until this point, he hasn't had any criminal history. We would have you, if you do take action on an out-on-bond case, we would have you just set a higher monetary bond, please.
At this time, your bond on count 1 will be $5,000. Your bond on count 2 will be $500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Your Honor, regarding his out on bond, state would ask that you.
Hold on, I'm not there yet. You're also not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to return to the victim's residence for any reason or to be within 1,000 feet of it. Do you understand? Now I'm at the out on bond case. What is it, Ms. May?
I'm sorry. State would ask that you revoke that and set it at no bond, Your Honor. He picked up the Bat TV May 31st. So it has been approximately 4 days before he violated the court order and escalated by also breaking her items.
I will revoke your bond at this time. Good luck, sir.
Dana Hart is medically young.
21MM3795. It's a battery dating violence. I'll appoint the PD. You want to waive his appearance?
Waive the appearance.
Or her appearance, I'm sorry.
Sorry, we'll waive her appearance. We do have some mental, I do have some mental health concerns. If you could include that in your consideration.
All right, I will, Counselor. I saw that as well. There is probable cause. The bond will be $500, or alternatively, I'd like to have her screened for mental health pretrial release. But if she doesn't qualify, the monetary bond will still apply.
Thank you, Your Honor.
Same conditions, no contact with the victim, no weapons, firearms, or ammunition, maintain a separate residence, one-time return with law enforcement, must comply with any doctor's orders and prescriptions that she's ordered to take. No alcohol or controlled substances without a valid prescription. Please tell me your name.
Matthew Henry.
21 MM 3721, a warrant was issued for your arrest for stalking, dating violence. Another judge has already found probable cause. I'll appoint the Public Defender's Office to represent you.
Can I speak?
If you have a question, you want to ask your attorney first.
It seems Mr. Henry has private counsel in this case, Your Honor.
Okay.
So we would, if that's the case, he hasn't had a chance to contact the attorney at this time. I don't know. Do you know his name?
All right, then I'm not going to appoint the Public Defender's Office at this time. You have an attorney, sir?
Yes, ma'am.
Okay, then I won't appoint them. But you want to call your attorney right away, okay?
Yes, ma'am.
He does otherwise, as a friend of the court, Your Honor, he does otherwise qualify for PTR.
What says the state?
Given the nature of the charge and the allegations within that warrant, state would object. I don't believe he's a good candidate based on the charge and the affidavits that are, or the statements that are in the affidavit.
He does otherwise qualify, Your Honor. Pretrial Services has their method of determining high and low risk. And he does otherwise qualify.
Your Honor, the allegation is that he broke into her house amongst other things.
Yeah. At this time, I'm going to place you on pretrial release and also require that you post a monetary bond of $5,000. While on pretrial release, you're not allowed to have any contact with the victim. Do you understand what that means?
Yes, ma'am.
You cannot call her on the phone. You cannot speak to her. You cannot send a text message to her. You cannot contact her on social media or using a friend or family member. You understand that?
Yes, Your Honor.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. You're also not allowed to return to her home for any reason or be within 1,000 feet of her residence or place of employment. Do you understand?
Yes.
Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name.
Ismail Khalkan.
21 MM 3806. You're here charged with battery, domestic violence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause.
Your Honor, Mr. Kalkan is unemployed. I don't know.
Hold on, I can't hear you. The
I believe
feedback.
Mr. Kalkan is unemployed. I don't know if a high monetary bond would be attainable for him. Keep
Your
that in
Honor.
consideration.
State worries about, he is here on a visitor visa.
Yeah.
So worry about him complying with court orders and coming back to court.
He has no criminal history, though, Your Honor.
All right, at this time, your bond is $500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, I understand, ma'am.
Do you still have belongings at that residence?
No.
All right, I'm going to order that you are not allowed to return to her residence for any reason at all. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name. 21MM342AW, you're here charged with 2 counts of battery domestic violence. At this time, I'll appoint the Public Defender's Office to represent you. Ma'am, did you wish to testify?
Yes.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Tiffany Triplett, Triplet.
State you may inquire.
Good morning, Ms. Triplett. Can you please state your relationship to Mr. Randolph?
It's my husband.
Are you afraid of him?
No.
Do you want to have contact with him?
Yes.
Has anything like this ever happened before?
We've had an altercation like 10 years ago.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Nothing happened. It was just an argument. It was never physical, so it wasn't anything physical.
Okay. And do you believe drugs or alcohol played a part in any of the arguments you had?
Absolutely not.
All right, thank you.
No questions, Your Honor.
All right, thank you.
Your Honor, may I have a second? I'm looking at some of the history.
Yes. I see prior domestic battery by strangulation, at least 2 of them, assault, battery, child abuse. 3 failures to appear. Is that what you have?
Yes.
Or you can say anything you want, but everything you say is being recorded and can be used against you later. So if you want to speak with your attorney first.
Your Honor, he does work full-time. He is, however, requesting a lower bond. As the victim's testimony suggests, maybe the facts in the arrest affidavit don't match up with the testimony. So we would have a low reasonable bond. He does work full-time. He does have community ties, all confirmed by his family.
Your Honor, there's also the bat DV by strangulation. There's also 2 violations of pretrial release on DV cases out of Seminole.
Oh, I see that.
May we approach?
Yes. All right, thank you, ma'am, for coming today. Mr. Randolph, at this time, your bond will be $500 on count 1 and $500 on count 2. You are not allowed to have any contact with any of the victims or witnesses in this case. Do you understand what no contact means?
Yes, ma'am.
You can't call them on the phone. You can't send a message through a friend. You can't contact them on social media. You can't go to her house. No contact. You understand that?
No.
You're not allowed to possess a weapon of any kind, firearm or ammunition. Do you have belongings at that house that you need to gather?
Some clothes.
All right, I'll order that you maintain a separate residence, and I'll allow a one-time return with law enforcement, but you can't coordinate that with your family.
Right.
You understand? I'll order you must comply with any plan set in place by DCF. I didn't see, was there any alcohol alleged in this incident?
I don't believe so, Your Honor.
I don't think so either. Any other conditions the state would request?
No, Your Honor.
All right, thank you, ma'am, for coming today.
Thank you.
Good luck, sir. Please tell me your name. 21MM3790. You're here charged with battery domestic violence. I'll appoint the Public Defender's Office to represent you. There is probable cause.
Your Honor, Ms. Rembert does otherwise qualify for PTR, no criminal history to speak of. And if you read the facts of the affidavit, I was trying hard to find if there was actual contact. I believe there is probable cause for contact and battery.
Well, she
However,
threw a drink at her and then shoved her. That's the battery.
I understand, but one of the facts suggests that the drink was tossed in the direction of, but that's where I started to question.
But pushed her in the chest. That's the battery, so.
I understand, Your Honor, I'm just.
State has no objection to PTR, Your Honor.
All right, I'm going to place you on pretrial release, but absent testimony from the victim here today, I have to order that you don't have any contact with your sister. You understand what no contact means?
Can I tell you something really quick?
Get close to the microphone and let me tell you one thing first.
Okay.
Everything you say is being recorded and can be used against you later.
Yes,
So if you want to talk about the facts, you should talk to your attorney about it first.
She was just clarifying something with me, Your Honor. I think
Okay.
we're okay.
All right. Were you living in the same house as Amanda?
No, we used to live in the same house.
Okay, so I'm going to order that you maintain a separate residence and you're not allowed to go to her house.
Okay.
You're not allowed to possess a weapon of any kind, firearm or ammunition. Any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am.
Your Honor, she's from Georgia. I mean, she returned to.
Oh, are you from Georgia? I'll allow her to return, thank you. Please tell me your name.
Dustin Delva.
You have a probation violation out of Miami-Dade in 18-11276 with no bond. I'll appoint the Public Defender's Office and we'll notify them that you're here. In 21MM3799, you're charged with resisting an officer without violence and possession of cannabis less than 20 grams. I'll appoint the Public Defender's Office in this case as well. There is probable cause. I'll stay your bonds at $500 on each count. You're not allowed to possess or consume a controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
And then in 21CT4016, you're charged with driving while license canceled, suspended, or revoked, second or subsequent offense. I'm going to appoint the Public Defender's Office in this case as well. There is probable cause. Your bond will be $500. You understand that you can't drive without a valid Florida license?
Yes, ma'am.
All right. Good luck, sir. Please tell me your name.
Jackson.
21 CT 549 and 550, you're here charged with driving under the influence and refusing to submit to a DUI test. There is probable cause, and I'll appoint the Public Defender's Office to represent you. Your bonds will stay at $500 and $100. You're not allowed to possess or consume any alcoholic beverage. You're not allowed to drive without a valid Florida license. Do you understand? As to 21 CT 24 and 21 CT 25, you're currently out on bond in those cases, and I'm revoking your bonds at this time. Good luck, sir. Please tell me your name.
Santiago Martinez.
21 CT 2167, a warrant was issued for your arrest for violating a condition of pretrial release by possessing or consuming illegal drugs. There is a $1,000 bond authorized on this. So Judge Bigney wants him placed on pretrial release with drug testing after 30 days. I'll appoint the Public Defender's Office to represent you as well. Good luck.
Your Honor, does he qualify for PTR, where you can put him on PTR with $1,000?
It says no, but that's what Judge Bigney ordered.
So is it PTR and the $1,000?
And 1,000, yes.
Thank you.
Please tell me your name.
Kayla Marchena.
A capias was issued for your arrest in 21 CT 2886 for failing to appear for arraignment on a charge of operating a motor vehicle without a valid driver's license. I'll appoint the Public Defender's Office to represent you, and your bond is $2,000.
Your Honor, I spoke with Ms. Perez Marchena, and $2,000 may be unattainable for her. If you could set a lower bond, a more attainable bond for her. If you look at her criminal history, the only thing I believe she had was littering. These are nonviolent offenses. And I'm sure she will be confirming here in court today that she will appear for the next court date if allowed to leave on a lower monetary bond.
Your Honor, Counselor, because it's a capias, I can't change it. So you're going to have to file a motion in front of the trial judge who issued the capias. Yes, ma'am. Now, before you say anything, everything you say is being recorded and can be used against you later.
Please. I understand that everything has been recorded, but I moved here about 6 months ago. I didn't mean to miss court. I came here. I'm from Kansas City, Missouri. Court and jail is at the same time. I showed up here thinking my court was here. I was never given the time of my court. I just showed up that day at 7 o'clock, and they told me it wasn't here, it was downtown. I tried and I tried. Court in Tampa has my car. I've been proving that I'm trying to fix my life. There's nobody that can sign me out because I can't get an ID from here.
I understand, but because it's a capias that was issued by another judge, this court can't change it. So it sounds like you have some defenses. Talk to the Public Defender's Office about that, and then they can file a motion in front of the trial judge. But I can't change another judge's capias.
So my bond will still $2,000?
Yes, it is.
Mr. Powell, bonded, Your Honor.
All right. Chad Siplin here?
I think we're determining.
Yes. Second session. And then do you have Mr. Cruz Avila? Ms. May, could you two approach and can you sign this plea agreement on behalf of another assistant state attorney? It's unsigned. It has a place for you to sign it, and I would like it signed, and I'm signing it too. Because in Marion County, they dot their i's and cross their t's. Do we know how many days credit he has? Yeah, it's 6-4. Thank you. Sir, please tell me your name.
Louis Grubb.
You're here in 21 CT 103 and 20 CT 8720. I have what appears to be a plea agreement signed by you for these cases out of Marion County. I'm going to ask the public defender if he can approach and show this to, I don't know if he's your client. Are you guys appointed? Okay. Can you show that to your client, make sure that's what he signed? Right, okay. Oh, and I need him to raise his right hand and be sworn. All right, sir, please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
All right, did you look at that plea agreement? And do you recognize that? Is that the agreement that you signed? And you want to enter a plea today to those two charges and be sentenced as it says in that plea agreement? All right, can you bring it back, Mr. Brands? I don't remember it off the top of my head. Yes, thank you. All right, so you're asking the court to sentence you, to adjudicate you guilty to each charge, sentence you to 10 days in jail with a $50 fine plus court costs, plus a $50 cost of prosecution. Is that right? And I see your initials here, so you understand all of the rights that you're giving up by entering this plea?
Yes.
Do you have any questions for the court about the rights you're giving up?
No.
You understand we're not going to have a jury trial here. You're going to enter this plea, and I'm going to sentence you today.
Yeah.
And that's what you want. You understand if you're on probation, this plea could violate that probation? So if you're on probation anywhere, I'm not saying that you are, I have to ask everyone this. If you are, this plea could violate that. So you understand that? And you understand if you're not a US citizen, this plea could subject you to deportation. All right. At this time, how do you wish to plead a driving while license canceled, suspended, or revoked, and driving while license canceled, suspended, or revoked? You can plead guilty or no contest. I'll accept your pleas of no contest. I find them freely and voluntarily made. I'll adjudicate you guilty, order that you serve 10 days in jail. I'll order that you pay a $50 fine plus court costs and a $50 cost of prosecution. Do we know how many days credit he has? All right, so I don't know how many days credit you have. I will ask if the public defender can work to figure that out, because if he's been in jail longer than 10 days, he'd be released on these charges. But I don't know if he has anything else holding him.
Your Honor, I thought the offer was,
I'm sorry, he's been in our custody longer than 10 days. However, I don't know what credit he may have from the other county. I can give you the Orange County time.
Oh, I see.
the offer was 60 days, correct?
No, 10 days.
That was the,
It's 60, Your Honor.
no,
It says 10.
that's the, I think that's the maximum.
Hold on. The plea agreement says 10 days. How many days has he been in here?
Something that
Hold on, they'll tell me exactly how many.
120,
120?
correct.
So he's been in jail for 120 days?
Just a moment, Your Honor, let me look through some of the emails I got this morning.
Ms. May, I see on the docket, the note says 60 days.
We don't, I've had zero contact with anybody, so we go off what the offer is on the docket.
Oh, that's not what the plea agreement says. So
Oh, I don't know.
regardless, he served 120 days in our jail,
The-
so it would be 60 days consecutive, right?
If I may, Your Honor, the Marion County Assistant State Attorney Becky Fletcher, and then the attorney from our office, Christy Fecani. And because he was in custody here at the BRC, she asked me to enter the plea on their behalf. There was the UTC was required as a charging document,
I had the UTC, I reviewed that.
and then Judge McCain or
McCune.
signed over the ability to, signed over your ability to take the plea on behalf of the COVID pandemic, the emergency administrative order, the inter-county and inter-circuit handling of criminal cases, and being duly advised in the premises. I'm trying to find the number of days he spent in Marion, though, but I don't think that's in my email chain that I have.
So I think regardless of the agreed upon disposition, he has served 60 days, which is the statutory maximum on each of those charges.
Even though I believe the plea offer was.
I can't hear you.
I believe the plea offer was, because on the waiver of rights and plea agreement motion, I think it gives the maximum sentence, and then lower down the first page, it gives the agreed upon terms and conditions of the plea agreement.
It does, and the agreed upon disposition is that the cases be run concurrent, which I'll order. So,
And then I believe that plea agreement that you have, Your Honor, is signed by everyone except
the Assistant State Attorney and the judge.
the attorney and Judge McCain.
That's correct. I signed it, as did Ms. May. So he's sentenced, and I'll give him the credit for the days that he's been in.
Thank you, Your Honor.
All right, good luck, sir. It would be 60 days on each. Correct. Thank you, B. All right, any other business before court is in recess this morning?
No, Your Honor, I appreciate, I didn't mean to cause any confusion. I thought if I had the three things, I'd be okay, but.
No,
apologize.
I don't think, I still think that went pretty smoothly, so. Thank you, everyone, for being willing to do that.
Thank you.
All right, court is in recess.
Yes, Shatar. First one. Okay. All right, hold on a second. All right, good afternoon. We're on the record at the BRC. Can I have the state put their names on the record?
Taylor May on behalf of the Office of the State Attorney.
Good afternoon, Your Honor. For Cheller, on behalf of Shahir Shatar.
1 second, sir. Hold on. I got a little routine I'm going to get through. State, can you put your names on the record again?
Thank you, Judge. Ashley Wright on behalf of statewide prosecution.
All right. And from the Public Defender's Office?
Tyler Brands on behalf of the Office of Public Defender.
All right. And the first case we're addressing is 2019 CF 13794AO. And counsel, what's your name on the record?
Yes, I'm sorry. Good afternoon, Your Honor. For Cheller, on behalf of Mr. Shatar.
All right. And good afternoon, sir. Can you tell me your name?
Shahir Satar.
Mr. Satar, you're here this afternoon in case 2019 CF 13794 for violation of probation. The judge signing your warrant in this case to set your bond at no bond. Counsel, is there anything you want to tell me?
Not this time, Your Honor.
All right. So your bond's going to remain at no bond, sir. We'll get you on to arraignment with Judge Lattimore unless you decide to waive his arraignment in the next few days. All right. Have a great day, sir.
Are you too, sir? Good.
Thank you very much, sir. Can I be?
Have a great day, sir. Have a great weekend.
Thank you.
All right. And see.
Welcome to an Econo meeting. You are entering the meeting now.
All right. Our next case I have is 2021 CF 6541AO. Counsel, can you put your name on the record?
This is Patrick Harris. I'm here on behalf of Kerry Gold.
All right. Mr. Gold, can you tell me your name, sir?
Kerry Golden.
Mr. Golden. All right, sir. Mr. Golden, you're here this afternoon in 2021 CF 6541AO on charges of burglary of a dwelling with a solid battery therein, armed burglary of a dwelling with a firearm, armed kidnapping with intent to commit a felony, armed kidnapping with intent to commit a felony in another count, attempted aggravated battery with a firearm, attempted robbery with a firearm in 2 counts, aggravated assault with a firearm in 2 counts, and possession of a firearm and commission of a felony in 1 count. I did review the charging affidavit in this case. I did not find probable cause as to counts 1 and 2 of this charging affidavit. Found PC for counts 3, 4. I did not find PC for counts 5. Found PC for counts 6 and 7, 8 and 9, and 10. State, are you asking for more time to remedy this charging affidavit?
Not at this time, Your Honor. As to count 3 being a punishable life offense, state is asking that you hold him no bond.
Okay. Counsel, do you have anything you want to tell me about counts 3 and 4?
Judge, at this time, I realize that he's not entitled to bond on that. However, I would ask that the court take into consideration his age. I've checked his record on the Orange County website, so it doesn't look like he has a great deal of history here. So I would ask that due to those circumstances, and there has been no, at least to this point, no finding of proof evident presumption grade, that the court set a reasonable bond in this case.
Well, are you asking me to make that finding at this time, or are you reserving your right to have an Arthur hearing at a later date with the division judge?
Well, depending if the court denies the bond at this time, we would reserve the right then to file that before the division judge.
All right, based on the facts in this case, the court and the fact that this defendant is already, and at least in the intent of this case, said that he wanted to leave the jurisdiction of this state. The court's going to hold him at no bond on counts 3 and 4, allow him to have an Arthur hearing in front of the division judge as to those counts. As the counts 6 and 7, the court's going to set bond in the amount of $10,000 on each count. As to counts 8 and 9, the court's going to set bond in amount of $15,000 on those counts. And as to count 10, the court's going to set bond in the case in the amount of $5,000. I'm going to release you on your own recognizance as to counts 1, 2, and 3, and 5. You are represented by counsel. But conditions of your bond are to have no contact with the victims in this case. You're not to return to the scene of the location where this incident happened. You're not to possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. As conditions of your release. And we'll get you on to your next division judge. Your attorney can file appropriate bond motions to have that full evidentiary hearing in front of that court. All right, have a great day, sir.
Judge, thank you very much.
Have a great day, sir. When is this available? Are we at the language line? I was asking, is it going to be language line or are we going to use the court interpreter? Okay. All right. Good afternoon, sir. Can you tell me your name?
Robert Crew.
Mr. Crew, you're here in 2021 MM 3781AO on a charge of trespass after warning. I did review the charging affidavit in your case. I did find probable cause for your arrest. I want to ask the state of Florida to have an offer to resolve Mr. Crew's case.
Yes, Your Honor, the offer conveyed was an adjudication, credit time served, and no return.
Mr. Crew, do you want to accept the state's offer of adjudication and guilt credit time served in this case?
Yes.
Can you raise your right hand to be sworn in as best you
With
can?
Mr. Crew for a few moments, Your Honor.
All right. Did we talk to all our pleadable people first already?
I talked to a few, Your Honor, but not everybody came.
Okay, I was asking where we are.
Yes, Your Honor.
I need a shirt size. All right, Mr. Crew,
I spoke with Mr. Crew. I believe he still wants to enter a plea, Your Honor.
all right, Mr. Crew, can you raise your right hand as best you can? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down, sir. Sir, you're here in 2021 MM 3581AO on a charge of trespass on property after warning. That is a first-degree misdemeanor. It's punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that? Do you want to enter a plea of guilty or no contest to resolve this case today?
No contest.
Do you understand by entering a plea of no contest, you're going to waive all the rights outlined on the plea form that's in front of you right now? Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
No. Other than schizophrenia.
All right. Are you suffering from the symptoms of your schizophrenia at this moment?
Kinda, yeah.
What's kinda, yeah? Are you having hallucinations,
No.
auditory or visual?
Just a little headache.
A little headache? Do you understand what's going on here? You tell me why we're here.
Yeah.
Can you tell me what you're doing right now?
I trespassed at the warning, yeah, and that's it. I'm trying to see when I am scheduled to either be leaving or just in the court, right? I don't know.
Well, right now you're here for initial appearance, but if you want to take an offer to resolve your case, which you have the right to do today, you can. If you don't want to take that offer and take your case to trial, you can do that as well. It's up to you.
I'm taking the offer.
Okay. Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand about entering this plea, if you're not a United States citizen, you could be subject to deportation.
Yeah.
I had an opportunity to review your charging affidavit in this case. I did find a factual basis contained therein. I accept your plea of no contest. Find your plea is freely and voluntarily entered. I want to adjudicate you guilty of the charge. I'll give you credit for the 2 days that you spent in Orange County Jail with 2 days credit time served. The court costs and costs of prosecution in this case are $273. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
For the record, I spoke with Mr. Crew as a friend of the court, Your Honor.
Yes, sir. That was it. Have a great day. Today is the 4th. Is it hot in here or is it me? Okay. I thought it was,
It's usually freezing.
yeah, okay. Good afternoon, sir. Can you tell me your name?
My name is Reynald.
Arthur hearings, bond hearings,
Is it Reynolds Mercer?
arraignment.
Yes, sir.
All right. Mr. Mercer, you're here for an out-of-county warrant from St. Johns County. The judge in St. Johns County set your bond at amount of $1,570.
Ready, sir. First of all, before we start, can I ask a couple questions? Because
Well,
this O1 is not for me, sir. Because I'm not allowed to pay no child support.
okay.
And it's been 5 years, I've been have Nadine, Louise.
Well, this looks like a child support writ, so
No.
I'm not sure.
It's not my O1, sir. Because those
So-
people trying to hurt me, it's been 5 years. They trying to hurt me with everything in this law. Drug poison, food poison, cigarette poison, clothes poison.
Okay.
Let me go into Subsamino County Hospital,
Uh-huh.
2016. Trying to come inside, trying to open the room door to hurt me. Alarm door running so crazy. It then catch the killer named Nadine and Jameson and Chris and some more people who are trying to hurt me for OJ and D. McKellen, who is stealing for the government.
Okay.
Is it task for stealing?
Well, in this case, the only thing I can do, sir, is tell you what you've been arrested for and tell you what the writ or amount bond is to get you out of jail.
I understand.
After that,
I understand what you say.
I got to get you to St. Johns County. You can talk to the judge
I
there.
understand what you say. You know
What's
what they
going
did?
on?
I was in Georgia for almost 2 years.
Yeah.
They come in Georgia last Saturday. It's still everything I have. I was sleeping in one van, and somebody I was working with. And then he let me sleep in the van. And then I was kind of find place to stay. I get proof for my apartment. I get proof for everything in this country.
All right.
They don't want me to get nothing.
Well, I need you to talk to the judge in St. Johns County about all of that so you can get all that resolved with him or her right now. I need you to have a great day, sir.
I don't know the draw Orange County, sir.
All right. All right. Have a great day, sir.
It's not for me. Those people owe me $3 million for my life.
Okay.
They wasn't for me.
All right. Good afternoon, sir. Can you tell me your name?
Maurice L. Williams Jr.
Say your name again.
Maurice L. Williams Jr.
All right. Mr. Williams, you are here for a case of 2021 MO 651 AO for a violation of the city ordinance violations for disorderly conduct. And I believe resisting possibly.
Your Honor,
Sorry.
I had a chance to speak with Mr. Williams. I don't know if the state has an offer of city county.
Well, this is a city case, so it's the offer is a withhold adjudication of guilt and court costs.
I spoke with him about the terms of that offer, Your Honor, and he wishes to enter a plea of no contest, I believe.
All right. Mr. Williams, can you raise your right hand as best you can? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, it is.
All right, put your hand down, sir. You are here in 2021 MO 651AO for a charge of disorderly conduct and violation of a state misdemeanor. The court, the penalty for both of those charges is 60 days in the county jail and a $500 fine on each. Do you understand?
Yes, sir.
You want to enter a plea of guilty or no contest to resolve both those charges today?
Yes, sir.
Which one, guilty or no contest?
No contest.
You understand by entering a plea of no contest, you're going to waive all the rights outlined on the plea form that PDs went over with you.
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
Yes, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
Yes, sir.
You understand by entering this plea, if you're not a United States citizen, it's going to end you up being deported from this country.
Yes, sir.
I did have opportunity to review your charging affidavit in this case. I did find a factual basis contained therein for both of the charges in this case. I'm going to accept your plea of no contest, find your plea is freely and voluntarily entered. I'm going to withhold adjudication of guilt as to both counts. I'll give you credit for the 2 days that you spent in Orange County Jail with 2 days credit time served. The court costs in this case are $223. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that?
Yes, sir.
You have a great day, sir.
Yes, sir.
Good afternoon, sir. Can you tell me your name?
Parrish, France Edwards.
Is it your last name Smith?
Yes, sir.
All right. Sir, you're here today in 2021 MM2680AO on a failure to appear warrant. The judge signing your warrant in this case set your bond in an amount of $1,000. Your bond's going to remain as set at $1,000. I'm going to appoint a public defender to represent you if you're not already appointed. You have a great day, sir.
There is an offer from the state, Your Honor.
Yes, Your Honor, the state did convey an offer of an adjudication, credit time served, and no return to Lake Eola.
All right, Mr. Smith, did you want to take that offer from the state of Florida? Why are we doing that? Madam, from statewide counsel, did you want to do all your defendants at one time? Are you here for the one RICO case, or are you here for the?
So, Your Honor, I'm covering the RICO case on behalf of
Okay.
someone in my office, but the rest of them are mine, Your Honor. So however the court would like to proceed, it's fine.
Everybody's here for the same trafficking case, looks that way.
That's fine.
All right.
You're good right here. Your Honor, I spoke with Mr. Smith in the back end just now here about the state's offer, and he would just like to have the bond stay at $1,000. He's going to work with our office to take a lot of this stuff downtown.
Okay. All right. Have a great day, sir.
Attorney.
All right, this is Mr. Michael Burrell. He has two cases, 2021 CF 6481AO and 2021 CF 6532AO. I want to appoint the public defender to represent him as to those cases.
We'll waive the appearance, Your Honor.
These are all warrants where the judge has already found probable cause for his arrest. Going to set his bond in 2021 CF 6481AO in the amount of $15,000. Condition of his bond, no return to the scene. Cannot possess any drugs or alcohol without a valid prescription. Must not associate with any known drug users or drug dealers. This is 2021 CF 6532AO. I'm going to set bond in count one, amount of $15,000, and count two, $100. Condition of those bonds that he not possess or consume any drugs or alcohol without a valid prescription. He not return to the scene of the location where that incident happened. Actually, I'm sorry. This is in that case, I did find, in 6532, I found probable cause, setting his bond at $15,000 as account one, $100 as account two. no drugs, no alcohol. May not return to the scene, may not associate with any known drug users or drug dealers. He's out on bond in case 2021 CF 2323AO. Of course, going to revoke that bond, set a new bond at $0. Going to appoint a public defender to represent him in all his cases if he's not already appointed. All right. All right. Good afternoon, sir. Can you tell me your name? Can't hear you. Can you speak up a little bit into the mic?
Harry Hudspeth.
All right, is it Hudspeth?
Hudspeth, yes.
All right, sir, you're here in 2021 CF 6563AO on charges of delivery of a controlled substance within 1,000 feet and 2 counts, conspiracy to deliver or sell, conspiracy to sell or deliver heroin, sell and delivery of fentanyl, sell and delivery of heroin, and sell and delivery of fentanyl. The judge signing your warrant in this case has already found probable cause for your arrest. Going to stay your bonds as set in the warrant in the amount of $10,000 as the counts 1 and 2, $7,500 as the counts 3, 4, and 5, and 6, for a total of $50,000. Condition of your bond is that you're not to return to the scene of the location where this incident happened. You should not possess or consume any drugs or alcohol without a valid prescription. You're not allowed to associate with your co-defendant. You may not have any contact with your co-defendants in this case. You may not associate with any known drug users or drug dealers while you're out on bond. I wanted to appoint the public defender to represent you in this case. You have a great day, sir. Thank you. Can you tell me your name, sir?
Michael Madison.
Mr. Madison, you're here in 2021 CF 6547AO on a charge of aggravated assault with a deadly weapon and battery. The court did review your charging affidavit in this case, and I did find probable cause for your arrest. We want to set your bond in count 1 in an amount of $3,000, count 2, $500. Conditions of your bond is you're not to return to the scene of this location. Actually, hold on.
I believe it was a random area, Your Honor.
Yeah, I think so. So I was trying
It's
to
a
make
random
sure.
area downtown.
Yep. Not return to the scene of the location, may not have any contacts with any victims or witnesses from this case. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Want to appoint the public defender to represent you in this matter, sir. You have a great day. Oh, sorry. Well, in condition of your bond, you have 48 hours from the time you're released from jail to report to the Orange County Sheriff's Office as a violent sexual offender, violent sexual predator, or sexual offender.
He's also requesting a copy of the arrest affidavit, Your Honor. He doesn't have one.
He should, doesn't he get that with his paperwork? A copy of the charges with his paperwork when he leaves? Or with his court paperwork? I can't hear you.
I'll print it for him.
Okay. All right, we'll provide it to you, sir.
Thank you, Your Honor. Thank you. Thank you, clerk.
Ramos Gonzalez, he refused court.
All right, this is 2020 CF 9921AO. Mr. Ramos Gonzalez, is he already appointed public defender?
I believe so in the previous cases, Your Honor.
Yes, Your Honor.
Yes?
In the
Okay.
previous-
19921.
All right. Do you want to waive his appearance this afternoon?
We'll waive his appearance on the out on bond cases. I mean, these are clearly addiction issues. He's been in Aspire, he's been in Crossroads for rehabilitation. So there's evidence that he has been working on this addiction issue. We would have you set bond on the current charges and perhaps take no action on the out on bond cases due to those circumstances.
All right, well, I can't do anything about his failure to appear writ without authorization from the sitting judge. So stay his bond in $0. That's a 2020 CF 9921 AO. Not taking any action on his auto and bond cases 2021 CF 1609 AO and 2020 MM 7416 AO.
Thank you, Your Honor.
Good afternoon, sir. Can you tell me your name?
Peterson, may I?
No, keep the mask on. Just tell me your name.
Peterson Demosthene.
All right, Mr. Peterson, you are here in 2021 CF 1550, a case out of Osceola County. The judge in Osceola County signed your warrant on the charges of lewd and lascivious battery on a person between the ages of 12 and 18 years old. Set your bond at none at this time. We'll get you down to Osceola tomorrow, and you can speak to the judge down there about your release conditions. Going to appoint the public defender to represent you while you're waiting. You have a great day, sir. What's going on with this case? This is you. Okay, I was like, I did not review this one, so I was like, hold on, give me one moment here then. All right, give me like, take a 2-minute recess. Let me look at this affidavit. All right, sir, tell me your name.
Javon Siplin.
Mr. Siplin, you're here in case 2021 CT 4025 AO on a charge of driving under the influence or property damage or serious bodily personal injury. I'm going to release you on pretrial release in this case. Conditions of your pretrial release is that you're not allowed to operate a motor vehicle without a valid driver's license. You may not possess or consume any drugs or alcohol. You'll be subject to random drug and alcohol testing at your expense. You don't qualify for the public defender's office, so you got to hire your own attorney or you got to represent yourself. Do you understand?
Sir.
All right. Have a great day, sir. All right, hold on. I have a stack. Did you separate them out, or you want to statewide cases together? Okay. All right, hold on. Hold on, Dexter. Let me get everybody. What's the first person? Bill? With a B? Gio.
Your Honor, he isn't one of the 4 co-defendants.
Yep. All right. All right, and then we had, all the other cases yours, correct, too? The other traffickings with
Yes, Your Honor.
the same individuals with the search warrant and stuff?
Yes, Your Honor. So the 3 arrest warrants that we have left that are all co-defendants along with Mr. Hudspeth would be Alexander Rodriguez Carrion, Edwin.
1 second, let me grab him.
I'm sorry?
Yeah, we'll grab, where? Oh, Rodriguez Carrion?
Rodriguez Carrion, first name Alexander.
No, I have Ramirez. Hold on. All right. Then you had, this one right, not too far from here. All right, who else you got?
I have Edwin Omar Colon.
Along.
This is Spanish interpreter case.
We're gonna have to wait for him at 1 o'clock.
All three of them are Spanish, Your Honor, but I believe maybe one may speak English, but all three may need the services of a Spanish interpreter.
And all right, Cologne and, was that it?
And Ramirez Ramos is the last.
Ramirez Ramos, those are both Spanish cases. All right,
I believe Rodriguez Carrion is gonna be Spanish also.
So those three.
3 Spanish cases. All right, we'll just, all right, I guess we'll deal with Mr. Gilliard right now, and then when 1 o'clock hits, our interpreters will be back online. So I'll call up the other 3 cases. Good afternoon, sir. Can you tell me your name?
Kevin Gilliard. Good afternoon, you too.
All right. Mr. Gilliard, you're here in case 2020 CF 1107BO on charges of racketeering, conspiracy to engage in racketeering, possession of firearm or ammunition by convicted felon, trafficking in fentanyl 4 grams or more, and 1, 2, 3 counts, possession of a place or structure for trafficking in a controlled substance, and unlawful communication with unlawful commission with two-way communication device. Goodness. The judge signed your warrants in this case has already found probable cause for your arrest. State, what do you ask me to do as to the racketeering charges?
On behalf of Mary Salmon, statewide prosecution, she's asking that he be held no bond. Apparently, he was found incompetent, but he's since had his competency restored. She's basically saying due to the nature of the charges, there is an armed trafficking, there's some other charges as well. And he was in Osceola County where he was in custody, so she's asking that the no bond be stayed.
All right. And I'm going to appoint a public defender to represent Mr. Gilliard.
Your Honor, I'm under the impression that he was deemed still
Yeah.
I was under the impression he was still deemed incompetent in that previous case, 17 CF 9645. I had an evaluation from August 23rd, 2020. It still says he was incompetent.
You said August 23rd, 2020?
2020, yes.
Okay.
I would have you take no action on the out on bond case due to those circumstances.
So what did the doctor on August 3rd, 2020 say?
He still deemed him incompetent. It is recommended that Mr. Gilliard be treated in a state forensic psychiatric hospital with competency restoration.
So did he go to the state hospital and then was released?
When we were looking at this case before session, we didn't find anything that restored competency, not to my knowledge.
As I'm asking, did he actually go to the state hospital?
I'm
And then was released from the state hospital? That's what I'm asking.
Recommendation from the evaluator, Your Honor.
So in that case, does anybody know? Did he go to the state hospital and got sent back, or
Your
did?
Honor, I don't have that information. All I have is that his competency was restored, but I'm checking now to see if there's a date or any other information that Ms. Salmon can provide.
Because if he went to the state hospital, they released him, they issued another, report before they send people back.
Understood.
All right, Mr. Gilliard, as the counts 1 and 2, I'm going to hold you as a no bond. As the counts 3, let's see, I'm going to set your bond, I'm going to say your bond amount of $5,000. Counts 4, 5, and 6, I'm going to set your bond amount of $100,000 on each count. As the count 7, I'm going to set your bond in amount of $25,000. As the count, leave 8, I'm going to say your bond amount of $2,500. Condition that you have no contact with your co-defendants in this case or any other witness. That you not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. And that you do not possess or consume any drugs or alcohol without a valid prescription. I'm going to order as condition of your release that you comply with Florida Statute 394.03 sub 2 sub F. And if somebody needs to file an affidavit that the money used to bond you out, once you're given a bond, was not used for, would not come from any illicit activity or used from the course or profits from this criminal activity alleged in this case.
Your Honor, did you say 394?
I think
It's 903.
903, there it is, sorry.
Sub 2, sub F.
903.04. 903.04 sub 2 sub F.
2F. 046.
046, apologize. I'm messing all up. 903.046, sub 2, sub F.
I was like, what?
I still wrong? That's still
No,
good?
that's right.
Okay.
Well, when you said 390 something.
Yeah, sorry, apologize. That's a problem being in civil training for the last 2 weeks.
Have that same problem.
No, not Nebbia Hold.
I was just.
The Florida statutes don't allow for Nebbia. Well, he just left before I could figure out what's going on with his other case.
Appreciate it.
Anybody find out if he was sent to the state hospital and was returned, another report was issued?
No, Your Honor, I could step out to make a call if the court. Yes, sir. Necessary.
All right. Well, since we're already holding him at no bond as to the other counts, I'm not gonna take any action on the other count. You guys can always move to revoke his bond as to the old case after you guys get that figured out. All right, have a great day, sir.
Is that case number?
Okay. Took no action on that one. 096.
That's what I get for not writing it down. All right, this is 2021 MM 3800AO on charge of trespass and occupied structure. Going to appoint a public defender to represent Mr. Armand. You want to try to bring him back on Monday or
We,
tomorrow?
yes, we do have an offer from the state if we can reset till Monday, yes.
You want to roll into Monday or tomorrow?
Your Honor, that's outside of the 20 or the 48 hours
Well, you actually have 72 hours.
if we show the.
If,
We can
But-
reset we can reset for Monday. That would probably be better because then I can talk to Ms. George about it, but we can.
no, so I was saying, if you think the weekend person can deal with it on tomorrow, then I don't know if he's just not
I trust the weekend. Yeah, we can.
not feeling the best today, or,
We can reset it till tomorrow. I trust the weekend.
all right. We'll reset Mr. Armand for 24 hours on stay his bonds amount of $500 until that happens, and see if we can resolve his case tomorrow.
That was 9645, right? That last one. That, case number.
All right,
That one that he took no action.
behavior. Good afternoon, sir. Can you tell me your name? Mr. Cruz, you're here in 2017 MM 8769AO for a failure to appear warrant. The judge signed your warrant. In this case, set your bond amount of $2,500. State you have an offer to resolve this case today.
Yes, Your Honor, the offer conveyed by the state was an adjudication credit time served.
All right. Mr. Cruz, is CR represented by the Public Defender's Office?
It's a 2017 case, so I would assume, Your Honor, 1 second.
I did speak with Mr. Cruz as a friend of the court, Your Honor, about the terms of the state's offer and the repercussions of entering a plea, along with the citizenship and probationary issues, and I believe he still wants to enter a plea, Your Honor.
All right, Mr. Cruz, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Now you put your hand down, sir. Sir, you're here in 2017 MM 5769AO on a charge of resisting an officer without violence. That is a first-degree misdemeanor. It is punishable up to 1 year in the county jail and a $1,000 fine. Do you understand that?
Yes, sir.
Do you want to enter pleas of guilty or no contest to resolve this case today?
No contest.
Do you understand by entering a plea of no contest, you give up the right to have a trial in this matter?
Yes, sir.
You understand you give up all the rest of those rights outlined on the plea form in front of you?
Yes, sir.
Are you under influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness? Has anybody forced, threatened, or coerced you to enter this plea? Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation? Do the parties stipulate to a factual basis in this case?
For the purposes of this plea, Your Honor, yes.
Yes, Your Honor.
Mr. Cruz, based on that stipulation, the court's going to find a factual basis for the entering of your plea. I'm going to accept your plea of no contest, find your plea is freely and voluntarily entered. I'm going to adjudicate you guilty of the charge. I'll give you credit for the
26.
46?
26.
26.
26.
This fan's blowing in my ear, sorry. 26 days in the Orange County Jail with 26 days credit time served. The court cost of prosecution in this case are $273. There's a $50 public defender application fee and a $50 public defender lien. I'll give you 2 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that?
Sir.
All right, have a great day, sir. Good afternoon, sir. Can you tell me your name?
Sean Michael Perry.
Mr. Perry, you're here this afternoon for a failure to appear warrant 2020 CO 650 AO. The judge signed your failure to appear, set your bond amount of $500. State, was there an offer you conveyed in this case?
Yes, Your Honor, adjudication, credit time served.
Mr. Perry, do you want to take the state's offer of adjudication of guilt credit time, sir?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Put your hand down, sir. Sir, you're here in 2020 CO 650 AO for a charge of mobile vending without a permit. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Sir.
Do you want to enter a plea of guilty or no contest to resolve this case today?
No contest.
You understand by entering this plea of no contest, you're waiving your right, so all the rights listed out on the plea form that's in front of you.
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes, sir.
I did actually have an opportunity to review your charging affidavit. In this case, it did find a fact, she was notice appear, I believe. Factual basis contained therein. I'm going to accept your plea of no contest. Find that your plea is freely and voluntarily entered. I'm going to adjudicate you guilty of the charge, give you credit for the 2 days that you spent in the Orange County Jail with 2 days credit time served. The court costs in this case are $223. Is there a $50 cost of prosecution for the county case?
It's a county ordinance, so I
County
would
ordinance,
assume
all right,
so.
all right.
I don't know.
So $223, I'll give you 1 year from today's date to pay that money direct to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that?
Yes, sir.
All right, you have a great day, sir.
I just have a moment with him. You want this? Yeah, thank you.
All right, good afternoon, sir. Can you tell me your name?
John Lyle Baker.
Mr. Baker, you're here in case 2021 CF 6423 AO for 3 counts of robbery with a firearm. You're also here in case 2021 CF 6434 for another charge of robbery with a firearm. State, what are you asking me to do to ask to all 4 of these charges?
As to all 4 counts in 6434 and 6423, as they are all punishable by life offenses, state is asking that you hold him no bond pending an Arthur hearing.
All right, and
No objection pending that Arthur hearing downtown, Your Honor.
all right, we're going to appoint a public defender to represent you, Mr. Baker. So, sir, in case 2000, so all in your cases, all your conditions would be the same. We're going to hold you at no bond. That's all the charges in both cases in your case, charge for your cases. I'm going to make it a condition of your bond that you not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You're not allowed to have any contact with any victims, witnesses, or co-defendants in this case. You're not allowed to return to the scene of the incident, scenes of the instances where these crimes happen. You're not allowed to possess any drugs or alcohol without a valid prescription. All right, you have a great day, sir.
Yes, sir.
Yep, 1 second. Good afternoon, sir. Can you tell me your name?
My name is Monty Bergeron.
All right, keep your mask on. All right, sir, you're here in case 2021 CF 6556AO for charges of possession of prazolam, possession of cocaine, and possession of cannabis. They reviewed the charging affidavit in this case, did find probable cause for your arrest. I'm going to release you on pretrial release and all your counts, conditions of your pretrial release that you do not possess or consume any drugs or alcohol without a valid prescription, be subject to random drug and alcohol testing at your expense. You don't qualify for the services of the public defender's office, so you're going to have to hire your own attorney or represent yourself. You have a great day, sir.
I'm going to get my own attorney.
I can't hear you.
Did you ask for me to get my own attorney? What's that?
Wait a second. All right. Say that one more time.
I didn't hear what you said. I'm sorry.
Which part? About the attorney part?
Yes, Your Honor, I believe so.
All right, sir, you don't qualify for the services of the public defender. The public defender is for people that are indigent, make too much money. Therefore, you're going to have to hire your own attorney, and you always have the absolute constitutional right to represent yourself in any criminal case. All right, you have a great day, sir. All right, tell me your name, sir.
Octavius Blaine.
Mr. Blaine, you are here in 2021 CF 6544AO on charge of possession of cannabis with intent to sell and deliver with a weapon, carrying a concealed firearm, possession of cannabis, and possession of cannabis with intent to sell and deliver. Did find probable cause as to those counts. I'm going to set your bond in count 1 in the amount of $5,000. I'm going to stay your bond in count 2. I'm going to stay your bond in count 3 in the amount of $150 each. I wanted to RR you or release you on own recognizance as a count 4. I'm also going to make it a condition that you are subject to pretrial release supervision. You may not possess any drugs or alcohol without a valid prescription. Do you understand that?
Can you say that again for me? Like the last couple of lines?
You're going to be subject to pretrial release supervision. You may not possess any drugs or alcohol without a valid prescription. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You understand? All right, have a great day, sir. All right, tell me your name, sir.
Brown. Daniel Brown.
All right, Mr. Brown, you are here in 2021 CF 276AO for a failure to appear warrant. The judge signing your warrant set your bond at $0. Your bond's going to remain at $0. I'm going to appoint the public defender to represent you if you're not already appointed. You have a great day, sir. All right. Tell me your name, ma'am.
Yeah, Brown.
Ms. Brown, you're here in 2 matters. The first one is 2020 CF 4431AO, and the other case is 2020 CF 4436AO. Both of those are for failure to appear. The judge in those cases set your bond amount of $2,500 on each count.
I
On each
dealt with it
case.
this morning. I went to downtown court.
You already went to court for these cases? Did you resolve the cases?
Yes?
Okay. Does anybody have any information?
Was time served on 4431 and time served on 4436.
All right. Have a great day.
Thank you.
Glad somebody's having a good Friday. Just letting you know, this whole day is Dexter's fault.
You can't see any of them.
All right. All right. All right, this is Ms. Forrest in case 2021 CF 6435 AO, 2021 CF 6422 AO. I'm going to appoint a public defender to represent her. She's a co-defendant in our earlier case. Go ahead.
The RICO case?
No, in the other gentleman that had the
We'll waive
4 counts of.
We'll waive the appearance, Your Honor.
All right, and for Ms. Forrester, the court's state you're gonna hold her in no bond, she requests?
Yes, Your Honor, as all of the charges are punishable live offenses, state asks that you hold him no bond pending an Arthur hearing.
No argument, Your Honor, pending that Arthur hearing downtown.
All right. All right, the court's gonna hold Ms. Forrester no bond as to those counts, conditions of her bonds. She not have any contact with any victims, witnesses, or her co-defendant. That she not possess any weapons or firearms. The weapons or firearms she has needs to be turned over to law enforcement within 24 hours of her release. And she is not to possess any, not return to the scene of the instances where these crimes happen, and not to possess any drugs or alcohol without a valid prescription. All right, this is 2021 CF 6557 AO. I want to appoint a public defender to represent Mr. Garcia.
We'll waive the appearance, Your Honor.
All right, Mr. Garcia, I did find probable cause after reviewing his charging affidavit for these cases. Going to set his bond in count 1, in the amount of $50,000. Count 2, going to state the bond in the amount, I believe it's I'll state the bond amount of $500. Condition of the bond that he not possess any weapons or firearms. The weapons or firearms he has needs to be turned over to law enforcement within 24 hours of his release. Had no contact with the victim in this case. May not return to the scene of the location where this incident happened.
I'm sorry, Dexter, was that a refusal or mental health?
Get mental health, yeah.
Thank you.
All right, tell me your name, sir.
Aaron Gibbons.
Mr. Gibson, you're here in 2021 CF 6545 AO on charge of possession of MDMA or ecstasy. They reviewed the charging affidavit in this case, did find probable cause for your arrest. Going to set your bond in this case amount of $500. Condition of your bond, not allowed to possess any drugs, alcohol without a valid prescription. Want to appoint the public defender to represent you in this matter. You have a great day, sir. Mr. Croker. All right, tell me your name, sir.
I'm doing all right. It's my birthday.
What's your name?
What's your name?
Agent Coker.
All right, Mr. Croker, you are here in 2021 CF 6552 AO on charge of robbery with a firearm, aggravated assault with a firearm. I did review the charging affidavit in this case. I did find probable cause for your arrest. Say, what are you asking that I do as the counsel 1 in this charging affidavit?
Your Honor, due to count 1 being punishable by life offense, state is asking that you hold him no bond pending an Arthur hearing.
And
No
I'll
argument.
appoint a public defender to represent you, sir.
No argument, pending that Arthur hearing downtown, Your Honor.
All right, sir, as to count 1, the court's going to hold you at no bond. Count 2, going to set your bond in the amount of $5,000. Condition of your bond that you not have any contact with the victim in this case. You cannot return to the scene, the location where this incident happened. We'll get you a copy of the charging affidavit if you're not unsure about what the allegations of this case are.
Say something.
You may not,
Can I say something?
hold on, let me finish. You may not have possessed any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You're out on bond in case 2021 CF 4910 AO. In that case, the court's going to revoke that bond. Going to set a new bond at $0. I already appointed a public defender to represent you in your, I'm going to appoint a public defender to represent you in all your cases. You have a great day, sir.
Take a seat.
All right, we're going to do Mr. Goodman, then we'll switch to our Spanish interpreter cases. Dexter. You hear me? Dexter. We're going to do all the statewide cases one by one because it's going to be too hard for the interpreter to do that. All right, tell me your name, sir.
Octavius Goodman.
Mr. Goodman, you're here in case 2021 MM3796AO for providing false information to law enforcement. They reviewed the charging affidavit. In that case, they find probable cause for your arrest. They're going to set your bond amount of $500. You're here also here in 2020 CF 9684AO for a failure to appear warrant. The judge signed your failure to appear warrant, set your bond amount of $0.
Your
I'm going
Honor.
to appoint the public defender to represent you in your cases.
Mr. Goodman
Right.
stated that that was sent to the wrong address, so he never had notice of that. Therefore, if you could set a different bond,
Yeah, they just
a
told me.
lower monetary bond.
All right, well, now with the authorization of the signing judge, as well as, I believe he was represented by the public defender's office at that time. The attorney had notice, you had notice. That's kind of how that works, unfortunately for you. Trying to figure out, you make $700 a week?
For me?
Yes, sir.
No, I don't know what he put on that paper.
How much money do you make a week?
Like $500. It depends. I do mobile detailing, so it varies.
What's the average? Well, what's your average for the month? Might be easier.
Like 15.
1,500? You should qualify, right? Yeah. All right, you do qualify for the services of the public defender.
This is not my fault.
So I'm appointed to represent you in the new case. All right. Have a great day, sir.
My fade to appear. How do I get that bond?
You gotta call the number, you gotta talk to your public defender. I don't know who you were assigned in that division for that judge.
Division 12 in front of Judge Calderon. His PD is Courtney Daly.
All right,
It's daily? All right, thank you, sir.
all right. Have a great day.
All right.
All righty.
Good morning, Your Honor. Good afternoon, sorry, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has already been sworn, Your Honor.
Good afternoon, Ms. L'Oreal. I have several cases this afternoon at the BRC down at the 33rd I need your help with. Let me know if you need to switch out at any time, okay?
Very well, Your Honor.
All right, I have a defendant with the headsets on. Can you have him tell me his name?
Edwin Omar Picon Colon.
Ivan without colon.
All right. Mr. Edwin Omar Pecan Colon. Sir, you are here this afternoon in case 2021 CF 6564AO on charges of trafficking and fentanyl of 28 grams or more, money laundering of $20,000 less than $100,000, and conspiracy to sell and deliver heroin. The judge signing your warrant in this case has already found probable cause for your arrest. Going to set your bond in count one amount of $500,000. Count two, going to stay your bond amount of $25,000. Count three, going to stay your bond amount of $7,500. Condition of the bond that you have no contact with any co-defendants or witnesses in this case. Do not return to the scene, the location where this happened. You may not associate with any drug users or known drug dealers. You may not possess or consume any drugs or alcohol without a valid prescription. Be subject to random drug and alcohol testing. Before you're able to bond out on this case, you need to comply with Florida Statute 903.046 sub 2 sub F, and somebody needs to file an affidavit with the court confirming that the money used to bond you out did not come from this illegal activity or any other illicit activity. Going to appoint a public defender to represent you in this matter. I'm not going to take any action on 2021 CF 1699AO.
What was that, count one bond, Your Honor, did you leave?
500,000.
500. Thank you, Judge.
Have a great day, sir.
Because that's the one, shouldn't have looked at it. Sorry, that's not my case, that's with a knife. So, yeah, I emailed, I think Tatiana has that one, I emailed it to her to,
Good afternoon, sir. Can you tell me your name?
Selvin Agustin. Agustin.
Selvin Agustin.
All right, then we. Okay. All right. Mr. Augustine, you're here in case 2021 CF 2811AO for a failure to appear warrant. The judge signing your warrant in this case sets your bond in amount of $0. Your bond is going to remain at $0 in this case. You want to appoint a public defender to represent you if you're not already appointed. I'm not going to take any action in your case 2021 CF 2812AO. You have a great day, sir. Tell me your name, sir.
Eric Albert Garcia.
Eric Albert Garcia.
Mr. Albert Garcia, you're here in case 2021 CF 6560AO for a charge of trafficking in fentanyl 28 grams or more. I did review the charging affidavit in your case. I did find probable cause for your arrest. I'm going to set your bond in this case amount of $500,000. Condition of your bond is you may not have any contact with any victims or witnesses or co-defendants in this case. You may not possess any drugs or alcohol without a valid prescription. You may not return to the scene of this location where this incident happened. You may not associate yourself with any known drug users or drug dealers. You need to, whoever bonds you out needs to comply with Florida Statute 903.046, sub 2, sub F, and filing an affidavit with the court alleging that the funds used to bond you out were not derived from this illegal activity or on any other illicit activity. I want to appoint a public defender to represent you in this matter. You have a great day, sir. All right, tell me your name, sir. Tell me your name, sir.
Alexis Ramirez.
Alexis Ramirez.
Mr. Ramirez Ramos, right?
Yes.
All right, Mr. Ramirez Ramos, you are here in case 2021 CF 6565AO on charge of trafficking in fentanyl 28 grams or more, money laundering in the $20,000 less than $100,000, possession of a place or structure for the purposes of trafficking a controlled substance, conspiracy to sell and deliver heroin, conspiracy to sell and deliver heroin in 2 counts. All right, counsel, you can put your name on the record.
Yes, Ina Bono on behalf of Mr. Ramirez.
Mr. Bono, do you want to tell me anything before I set release conditions for Mr. Ramirez Ramos?
Your Honor, I don't have any of the probable cause affidavit to this, so I don't know any of the facts.
It was a warrant, so.
I don't know what the facts are on the warrant, so I'd ask the court to set a reasonable bond. I know it's $200,000, I believe it was $200,000.
Yeah, so it's the warrant bonds on the warrant are $200,000, $225,000, $1,000. $7,500, and $7,500. And the allegations these allegations extend from March 31st of last year till February 10th of this year.
Yes, Your Honor, we're asking the court to set a reasonable bond on count one, which is 200,000. We're asking for 20 or 25,000.
Okay. All right, well, I think the standard bond amount actually for these counts is what I've been sending the other co-defendants at, which is actually $500,000. So, yeah,
That is correct.
for 28 grams or more is $500,000. All right, so Mr. Ramirez Ramos is count one, will set your bond amount of $500,000. It's count one. You want to stay your bond in count two in the amount of $25,000. Count three, 1,000. Counts 4 and 5, we're going to stay your bonds about $7,500 on each one of those counts. Conditions of your bond that you not have any contact with any witnesses or co-defendants in this case. That you not possess or consume any drugs, alcohol without a valid prescription. You may not associate with any known drug users or drug dealers. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You may not, before you bond out on this case, whoever does bond you out needs to file an affidavit with the court complying with Florida Statute 903.046, sub 2, sub F, confirming that the monies used to bond you out are not derived from any illicit activity, including the activity alleged in this warrant. When you're arrested in this case, you're out on bond in case 2020, CF 10023 AO. In that case, the court's going to revoke that bond. When I set a new bond, it's $0 in that case. You already have, Mr. Bono, are you on the old case as well?
The old case, I was
Okay.
gonna represent him on the new case as well.
You have Mr. Bono representing you in both your cases? You have a great day, sir.
Your Honor, would the court consider lowering the bond on count one from the standard 500 to more reasonable? I think Mr. Ramirez has ties in the Central Florida area. I don't think he has a
Well, not with the alleged allegations that this activity continued after he was already arrested on trafficking charge back in August of last year. He continued to, just went back to business as usual, at least with the allegation to say. So, and there's a part amount of equity amongst the other co-defendants. It doesn't make he's be any different circumstance than the rest of them. So have a great day, sir.
Hang on.
Right, I'm revoking your PTR. So,
Is out on bond with PTR?
he had a PTR as a condition of his out on bond case.
Your Honor, I have the next case too.
Okay. Can you tell me your name, sir?
Alexander Rodriguez Carrion.
Alexandre Rodriguez Carrion.
Sir, you are here in case 2021 CF 6566AO for a charge of armed trafficking of heroin within 28 grams or more, trafficking in fentanyl of 28 grams or more. You're also here in case 2021 CF 6567AO on charge of trafficking in 28 grams or more of fentanyl and money laundering of $20,000 less than $100,000. The judge signing your warrants in the first case, 2021 CF 6566. I did review the charging affidavit in this case. It did find probable cause for your arrest as to that charge. 2021 CF 6567 is a warrant. Judge signing the warrants already found probable cause for your arrest as to that charge. Say, what are you asking me to do as to count one in the charging affidavit, 2021 CF 6566, as a life offense?
Is that for the armed trafficking one?
Yes, ma'am.
I would ask for no bond.
Mr. Bono, are you asking that I find proof evidence presumption great right now, or you want to take that up with the judge downtown?
I was just gonna make an argument that the presumption is not great because there's one of the probable cause affidavit, there's a search warrant execution, and it's not clear. It says there's a cloth sack containing approximately 84 grams of suspected heroin was located near Alexander. Contact was made with him. There's multiple occupants in the residence. There's no statement from Mr. Alexander saying that belongs to him. It's just mere proximity alone is not enough to convict him. So the presumption is not actually great in this case. So unless there is some sort of a DNA fingerprints or any statement or any witnesses seeing him with his suspected drugs, that does not mean that he knowingly possessed it. I think the officer wrote on there somewhere, if I'm not mistaken, it was constructive. This is the fifth line from the bottom. It was a constructive possession of the fentanyl located in this land. There's multiple people living in the residence. There's no proof that this is his room. There's no mail.
Well, he said it was his room. He said he lived there. He said the gun was in his room.
He said the gun was in the room. He said the drugs.
Yeah, I'm trying to. You say like that, like he wasn't a resident of this house. That he's
No,
okay.
I'm not saying he's not a resident.
Okay.
I'm saying there's other people living,
Correct.
staying in the house. He said, I have a gun located in this room. But then other people living in the house, they could have possessed the drugs. Doesn't mean the drugs. They still have to associate the drugs to carry on. The gun is legally possessed. It's not a convicted felon. He can legally possess a gun. He says, I have a gun. There's no crime there. And then drugs happen to be in a mere proximity. Again, the state has to show that he has some sort of knowledge to tie him to the drugs. Mere proximity is not enough without showing the element of knowledge that he knew that the drugs were his. And I don't think anywhere in the affidavit the officer says anything about knowledge. He says it was near, but near can be 5 feet away, can be 10 feet away, it can be all kinds of things.
If I can interject, this particular case is the result of an ongoing investigation of the drug trafficking organization. Mr. Rodriguez Carrion happens to just be one of 7 co-defendants in this particular case. 2 of the other co-defendants in this case, which just came before the court, Mr. Rodriguez Carrion in this particular case was charged with conspiracy to traffic in fentanyl greater than 28 grams. At the time of the arrest, Mr. Rodriguez Carrion actually had fentanyl on his person and actually admitted that the gun was his at the time of the arrest. Your Honor, this isn't just a one-time. This isn't just a one-time deal, Your Honor. The state would submit to the court that these are known drug traffickers, and this is sort of.
All right.
So, Your Honor, I would just ask that the court take that into consideration.
Well, the problem with the Archer standards, I'm stuck with the 4 corners of the affidavit.
Yes, Your Honor.
Unless that you guys always can have you always can request an Arthur hearing later on, and you have his bond revoked at that time. It's count 1 in 2021 CF 6566 AO. We want to set your bond in amount of $1 million as count 1. Count 2, going to set your bond in amount of $500,000. Condition of your bond is you're not allowed to possess and consume any drugs, alcohol without a valid prescription. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You may not have any contact with any victims any witnesses or co-defendants in this case. You may not, hold on a second. You may not associate with any known drug users or drug dealers. These same conditions are going to be the conditions I'm going to outline in the next count case too. Both cases are going to be the same conditions. Yeah, same conditions. Different, like bond amounts will be different, but the same conditions. You still need to comply with Florida Statute 903.046, sub 2, sub F. And whoever is bonding you out needs to file an affidavit with the court affirming that the money used to bond you out did not come from any illegal or illicit activity, either from this case or any other criminal activity. As the 2021 CF 6567 AO, the court is going to set your bond in count 1 amount of $500,000. Going to stay your bond in count 2 an amount of $25,000. Given the same conditions as your previous case: no drugs, no weapons, no co-defendants, contact, no return to the scene. And you must comply with Florida Statute 903.046, sub 2, sub F, no drug dealers, no drug users. You have Mr. Bono representing you in this case. So have a great day, sir.
Your Honor, that's all I may be excused.
Your Honor, I believe that's all the cases that statewide has before the court today. May I be excused?
Yes, ma'am. Have a great weekend.
Thank you, Judge. You too.
Tell me your name, ma'am.
It's Jenna Haney.
What happened to, Creole, that's what, okay, sorry. All right, sir. I think that was my last Spanish case.
Okay, very well, Your Honor.
Thank you, sir. Have a great day.
You too, Your Honor. Thanks.
All right. All right, Ms. Haney, you're here in case 2020 CF 117, charge of petty theft with 2 prior theft convictions. The judge signing your warrant in this case has already found probable cause for your arrest. Going to stay your bond in an amount of $1,000. Condition of your bond that you not have any contact with any victims or witnesses from the next case, not return to the scene or location where the incident happened. You are out on bond in case 2020 CF 628AO. In that case, the court, yes, ma'am.
It's actually an entry error. She's in custody on that case already.
She's already in custody on the case?
For a transfer order, correct.
Hold on.
So that's an entry error. They should not have placed a detainer for that.
Was she out on bond when this happened or not?
Yes, Your Honor.
That's what I'm
She's
asking.
in custody on the case. She was brought here on a transfer order for that case. So I didn't check the out on bond status.
Because you just said, because what I have said she bonded on January 16th of 2020. Did she fail to appear at a later date and then the judge issued a warrant? Like,
You can revoke it.
Return for court order
Yeah.
charge, that's the same case number as the one out in bond.
does she ever bond out?
I believe so.
Because it looks like she bonded, like, according to paperwork you provided me, is that she was arrested on the 15th of January of last year. She bonded out on January 16th of last year.
Picked up the new law.
And then she picked up another offense. At least the warrant says she committed another offense on December 19th of 2020.
She's already here on the case on a no bond. So what would
She's already no bond. That's what I'm asking. Like, so the judge took action on her bond already. Okay. All right. So I'm not going to take any further action on that case then. All right. I'm going to appoint a public defender to represent you, ma'am, in your new case.
Can you explain it to her very briefly, Your Honor? She had a question. Or she didn't have a question, she was a little confused.
I guess apparently you're being held on no bond. That's your old case, 2020 CF 628. The judge has already took action on your case, so I'm without jurisdiction to take further action on your case. But I'm saying, as in the new case you're arrested for, which is a petty theft that happened on December 19th of last year, that's what is alleged. I'm setting your bond amount of $1,000. Conditions, no contact with any victims or witnesses, no return to the scene. Want to appoint the public defender to represent you in that case. Good afternoon, ma'am. Can you tell me your name?
Good afternoon, Delvonna Harris.
Ms. Harris, you're here in 2020 CF 14184AO for a failure to appear warrant. The judge signing your warrant set your bond amount of $2,500. Conditions, your bond's gonna remain the same as set. I'm not gonna take any action on your 2021 CF 1020AO case. So have a great day, ma'am.
Thank you, sir.
Good afternoon, sir. Can you tell me your name?
Basically, Hightower, I feel like my civil rights has been violated, Your Honor.
Okay. Sir, you're here in case 2021 CF 6553 AO on charge of possession of cocaine, tampering with physical evidence, possession of drug paraphernalia, loitering and prowling, resisting officer without violence, attempted destruction of evidence. I found probable cause for all the counts except count 2. I'm going to ROR you as to that count. I'm going to set your bond in count 1 amount of $500. I want to set your bond in the remaining counts amount of $150. Condition of your bond is you not allowed to return to the scene or location. You may not possess or consume any drugs or alcohol without a valid prescription. I'm going to appoint the public defender to represent you in this case. You have a great day, sir.
He was inquiring which count had the ROR.
Count 2, the tampering with physical evidence. They doubled it. The actual charge was the last count.
Your Honor, I entered the store and bought a juice.
Hold on just a second, Your Honor.
Well, Mr. Hightower, I can tell you this like this. You can tell me your full story that you want to tell me right now. Or, I'll give you 2 options. Everything you tell me is on the record. And the people over here, the state of Florida, can use that against you. You think you can be helping yourself. You gotta cover your nose for me. Just listen to me for a second. People over here, the state of Florida, can use that against you at a later date for a trial. Or, you can not tell me anything. Listen to your attorney, save your defenses, and possibly get this case worked out well before that happens.
Your Honor, my attorney stepped close to me after you're already telling me what we're here for. He haven't seen me until I stepped here.
Yeah, I understand that. So you can, that's what I'm saying, you have 2 choices.
My civil rights were violated.
Yes, okay.
I could buy a juice in the store and eat my food. There's no law and proud there. So officers that rush these places and then follow me a block down the road and want to talk to me, and I just walk and chase me almost into a canal.
Okay.
It's pretty much a crime in itself.
Okay.
Once we do a surveillance camera thing here, I left a store, a public establishment, and drink a juice. They have a habit of rushing this store for drug dealers. So when it's all said and done, you're giving them probable cause of violating my civil rights. So a lawyer and proud is standing around somewhere moping back and forth. And I don't know what it says.
That's not even the charge. So that's not exactly my point.
Yes, sir.
So you understand what you think loitering and prowling is not what that is.
I could be lawyer and proud by walking to the store buying a juice.
That may not have been the complete story. So I don't know what happened before then, don't know what happened after then. So that's what juries are made for.
Right, that's why
Me as a judge right now, my role is to, based on the affidavit that I have, is determine whether those probable cause contained therein and set release conditions.
he used to consult with me.
Consulting you, but for factual disputes, listen to me. For factual disputes, I can't help you with a factual dispute. I can't.
Got case law in his mind?
He can't help you with a factual dispute. Nobody can help you with a facts dispute except the jury. That's how, unless you decide to have a trial by a judge.
So how many felonies do I have?
Say again?
How many felonies am I standing in front of?
Right now, you have 2, I believe.
They try to give me 3 felonies?
Right now, I think you got a possession of cocaine and then the attempted tampering with evidence is a felony as well. So I think I remember 2.
Didn't you just do away with tampering evidence?
No, so you got charged so they charged you with tampering and attempted tampering. So I got rid of the tampering.
They sound like some cowboys.
I don't know, with the allegations, I believe that they say you threw a crack pipe, which is attempted tampering. It's not an actual, tampering, you have to destroy the evidence. So in this case, they claim that, I don't know if it's true or not, I wasn't there.
This case is gonna start me to pretty much go ahead and start videoing the way the police is doing those people off of Jordan over there. They're pretty much, it's a witch hunt over there with drug dealers, and what they do is they sit there.
Well, Mr. Hightower, I don't want you to say anything, because I want you to put into context what you're saying to me right now.
R&R on all that.
Wait, time out. You're upset with the police because they're attacking drug dealers, right? That they're going after, wait, time out, don't talk, because you're gonna say something incriminating. I want to bring something to your attention, so you can probably make it a little clearer about what you're saying. All right? You're saying that there are allegations that they're going after drug dealers. When allegations in this situation is that you possess crack cocaine and a crack pipe, So wouldn't you be part of that situation as well, if that's true? So,
Crack cocaine. They found crack cocaine. If you walk down Georgia, you probably gonna find crack cocaine, needles, and all that. I don't do none of that. So when
Okay.
they pick up off the ground, maybe a block away, it has nothing to do with me. I was standing purchasing a juice. I'm eating food. Usually crackheads don't go eat food and then go smoke crack, right? So if I purchasing food and they rush up, they stop, they look around. If you can see the video of the whole thing, you
all right.
probably summons.
Then you, that's perfect. It sounds like this would be a great trial for your attorney. All right?
No, I'm just saying, because it's upsetting for me to be here, because no one would want their child here or their self here and lay around here hurting their back when all I did was went and bought me a juice. So once we see the surveillance camera of me.
Once again.
Wait, once we see the surveillance camera of me, how do you rest up and look around, follow me a block away, pull up in the grass, and then just want to freaking talk to me? Now, you got a hotel a block away. Last week, there's a guy, Pepe, that Orange County Sheriff hangs out with in the row here, and he walks around with an AR-15 in his hand, and I just have to come through there. And when I go to the breezeway, he sees, hey, come here. I take off running. I'm going to do that again. I don't know why a man's coming at me with an AR-15 and the sheriff's like, well, hey, come here. I could be mistaken identity. These are the things that they're doing over there. These are the things that I got to stop doing what I do physically as far as what's harming my body, and sit there and document this and put this on Facebook. Put this on, because my grandma just died at 98 on her birthday, Muskogee, Oklahoma. This is the turning point for me. Since 18 to 54. This is my goal now. I've known these guys when they were young, when we were young. I know 90% of this jail. I watched them build this jail. It's time. It's time for them to stop taking minorities. And whether they're minorities or not, the unprivileged, people that don't have a lot, and think they can just come and do a witch hunt when they want. These are cowboys out there. Pull up, look around. Oh, well, what's he doing? He's back in my squad car. They're wasting millions of dollars of taxpayers' money to do this. I don't have to talk to him. I don't want to talk to him. I can't read the report because I can't see. They put my glasses in the dark. But y'all, I appreciate that, but this is gonna be it. My nephew's a federal prosecutor. I'm trying to help him get me a case while I want all this. It's done.
Okay. All right. Make sure you take your information about your attorney. Have a great day. All right. Tell me your name, sir.
Markel Isom.
So, Isom, you're here in two matters. The first one is 2021 MM 3789AO for charge of resisting officer violence. You're also here in case 2021 CF 5289AO for possession of a weapon or firearm by a convicted felon.
Yes, sir.
As to your felony case, the court did find the judge has already signed a warrant finding probable cause for your arrest. Set your bond amount of $5,000. Condition of your bond that you're not allowed to possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release.
Yes, sir.
1 second here. Did I not have the resisting case too?
There's a resisting and an out on bond.
Yep. Hold on. 1 second. Something happened. I saw it before. There it is. Okay, here we go. All right. As to your 2021 MM 3789AO, I did review the charging affidavit, did find probable cause for your arrest. Going to stay your bond amount of $500. Additionally, your bond now returned to the scene of the location. Not allowed to possess any weapons or firearms. Any weapons or firearms need to be turned over to law enforcement within 24 hours of your release. You're out on bond in case 2020 CF 14898AO for another charge of possession of a firearm by a convicted felon. We're going to revoke that bond. We're going to set a new bond at $0. Want to appoint a public defender to represent you in all your cases? You have a great day, sir. Catherine, ma'am, can you tell me your name?
Joanna Joy.
Ms. Joy, you're here in case 2020 CF 6482AO for 3 counts of neglect of a child and 1 count of DUI property damage with or personal injury. Did review the charging affidavit in your case. There was a warrant in your case finding probable cause for your arrest signed by a judge. Judge in that case set your bond amount of $3,000 on each one of your neglect of a child charges and $2,000 on your DUI. The conditions of your bond that you not possess or consume any drugs or alcohol while you're out on release in this case. And
Your Honor,
I want to point a public defender to represent you. Can you find out where the children are?
I just wanted to bring it to your attention on the warrant. It has 3 counts on on count 1. So it looks like it's a total of 5. Are you seeing that?
I'm looking at the actual warrant, and the actual warrant says
Just 3.
1, 2, 3.
Okay, I just wanted to make sure that she didn't have
Yeah,
to pay
and the charging
9,000 on
affidavit's a
count
little
1.
inconsistent from the warrant.
Okay, I just wanted to make sure that that wouldn't be a discrepancy later if she were to try the bond down. I didn't want it to be 9,000 on count 1.
Hmm. And were these children sheltered by DCF? Does anybody know?
It doesn't mention within the affidavit, Your Honor, or the warrant.
Well, I'm not trying to see where they are right now. I don't want to conflict with another dependency judge's determination.
I'm not sure, Your Honor. I don't have any notes, and it's not in the warrant.
All right, I'll take this back with me. So I'm not sure if DCF was notified when this incident happened. This Ms. Page, do you have any information?
Ms. Joy, informed me that
Is where, to where the children are?
About whether it was a DCF investigation, where the children are?
I don't have access to the warrant.
Go ahead.
Ms. Joy did say that DCF was notified, but then I figured there would be a record of that from DCF.
So where are the children right now? Are they in DCF custody?
I believe they're with her sister.
So as I was saying, the DCF removed the children from her custody and placed them with the sister, shelter with them with the sister.
I don't know if that's exactly what happened, but I know that Ms. Joy informed me that the children are with her sister and that DCF had been notified. I don't know if those two interacted, whether the DCF ordered the children there, but for now, they're all with the sister.
All right, until we can get a full hearing, the court's gonna order no contact with the children, no contact with any child under the age of 18 years old. That's no drugs and alcohol, correct, already?
Yes.
Are you subject to random drug and alcohol testing at your expense? I'm going to appoint a public defender to represent you in this matter. All right, have a great day, ma'am. All right, tell me your name, ma'am.
Kiera Lee.
Ms. Lee, you're here in case 2021 CF 6558 AO on a charge of aggravated battery with a weapon causing great bodily harm, grand theft of a motor vehicle, and aggravated assault. I did review the charging affidavit in this case. I did find probable cause for your arrest. I'm going to set your bond in count 1 in the amount of $50,000. Count 2, going to say your bond amount of $150, and count 3, $150. Conditions of your bond that you not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint a public defender to represent you. You may not have any contact with any victims or witnesses from this case. You may not return to the scene of the location where this incident happened.
Your Honor, I believe it potentially was her house.
That's what I was trying to figure out, whether it was her house or the other
I
person's house.
believe she lived with her
Okay,
boyfriend.
all right, so I'll do this. Instead of saying no return, I'll say maintain a separate residence. And I'll make these all conditions of pretrial release. Yes, ma'am. Condition, bond and pretrial release.
Your Honor, the bond amount is unattainable for Ms. Lee. She's informed me if you could lower that amount. I believe on the arrest affidavit, the bond amount was set at $10,000.
This is the one where somebody got stabbed in the eye, correct?
That's what's alleged in the arrest affidavit, Your Honor. But again, if the bond is unattainable, it may be as effective as no bond.
All right, well, she can address that with the division judge with a full bond hearing. That's the allegations that I read in that affidavit seems pretty egregious to me. But there may be a different opinion as to the division judge.
I understand, Your Honor, but still, I
have no evidence.
You have to sit here
You're telling me
because
that's
you don't have enough
unattainable?
money.
I have no evidence. She didn't testify. I don't know anything about what's going on. So right now, I'm not exercising my discretion to have that bond hearing. She can have that bond hearing she's constitutionally entitled to in front of the division judge. All right. Tell me your name, sir. Good afternoon.
Tell you my name?
Yes, sir.
Antoine Lee Luckett.
Mr. Luckett, you're here in case 2021 CF 6523AO for a charge of fleeing attempt to elude law enforcement with lights and sirens. Did the judge sign your warrant in this case has already found probable cause for your arrest. You want to set your bond in this case in amount of $2,500. Additionally, your bond, you're not allowed to operate a motor vehicle without a valid driver's license. You have a great day. I'm appointing the public defender to represent you. You have a great day, sir. Tell me your name, sir.
Andres Mazet.
All right, you can cover your nose, Mr. Mazet. Sir, you're here in case 2021 CF 6555AO for a charge of possession of controlled substance. Reviewed the charging affidavit, did find probable cause for your arrest. Want to release you on your own recognizance as to this charge. Conditions of your release that you're not allowed to possess or consume any drugs or alcohol without a valid prescription. Not allowed to associate with any known drug users or drug dealers. You understand me? Going to appoint the public defender to represent you in this case. You need to keep in contact with your attorney at least twice a month. You understand that? That's the number on a piece of paper. You need to call them. Keep in contact with your attorney twice a month. Not just, that's my public defender. He's assigned to my courtroom. Okay. Mr. Wesley has public defenders assigned to every criminal courtroom we have. So wherever courtroom you're going to be sent, you need to keep in contact with that attorney. All right. Have a great day, sir. Good afternoon, sir. Can you tell me your name?
Marcus McCoy.
Mr. McCoy. Ms. Page, do you have an updated? I don't have no criminal history, nothing, zero. Wasn't interviewed, it said, so.
Is here on an enforcement bond.
Yeah.
So there wouldn't be a history, let's see.
So I need to see him, or?
You need to see him because he bonded out before he came to initial appearance when he was last here.
Okay.
Let's see.
They brought him back?
Yeah, the bondsman came off of the bond.
All right. Was he interviewed the last time he was here?
Was.
Okay.
Well, he has 5 felonies, 5 misdemeanors. His last conviction was in 2015 for marijuana possession. He has no out-of-state history. His convictions include petty theft and the marijuana possession.
All right, does it qualify for PTR?
You did not last time.
I had no idea. Mr. McCoy, do you have a job?
Yes, sir.
Where do you work?
I am a sound engineer and I own a production LLC.
Okay. Is that you do that by contract or are you employed by somebody?
No, sir. It's more so kind of lucrative per se, but I basically own my own LLC and I conglomerate with other people that need my services.
All right.
He has a relatively limited criminal history, Your Honor.
Yeah, as I figured, my goal, Mr. McCoy, was to release you on pretrial release in this case for this charge of possession of MDMA or ecstasy. I did find probable cause for your arrest as to that charge.
Your Honor, may I be heard on the probable cause? I know you, Your Honor, read the arrest affidavit. It was a friend's car he was getting a ride with. The officer assumed and wrote in the affidavit that anybody sitting in a passenger seat would see the contents of the door, what they refer to in the door pocket.
Constructive possession case. I mean, it's a constructive possession case. I mean, I'm not, the facts aren't exactly, mind blowing, but probable cause is extremely low determination.
It's just, he didn't have actual possession, so I assume
No.
that because he was just nearby, didn't
Constructive
even
possession
drive
is
to
possession.
construct. I didn't even think it rose to constructive possession, because if it's not his car, and he's just getting a ride and it's in the car, I just,
He has the ability to exercise dominion and control over said drugs.
Yeah, I mean, that's what I said. This is not a reasonable to doubt kind of situation. This is
Your Honor, but
probable cause, which is lower than preponderance of the evidence. It's like the lowest standard we have as far as legal proof.
I understand it's also a totality of the circumstances, where if he's perhaps interacting with the side door at some point, or there are facts saying that he saw it there, just the officer assumed that he saw it there. He never stated that he saw illegal substances in the
Correct.
side door pocket, whatever.
Your Honor, respectfully, these are all arguments for a motion to suppress, not for a PC
It's
determination.
not even an argument for motion to suppress. It's an argument for whether it's maybe a motion to dismiss maybe and/or, which I've seen case law about that, and/or trial, as if the state of Florida even turns a foul on it. So right now, it needs to set release conditions.
If he does qualify for PTR,
I want to put him on pretrial release.
we would agree with pretrial release.
I'm going to no drugs and alcohol. So, Mr. McCoy,
Yes, sir.
all right, no drugs and alcohol.
No, I do not
All
drink,
right.
sir.
I'm just telling you, no drugs and alcohol. I want to, since you don't have any other prior drug history, I'm not going to drug test you. All right, so you had prior drug history? That's what I was asking. I thought you said petty theft.
Just the cannabis and a petty theft, Your Honor.
Cannabis when? 18?
2015?
15? All right, so 6 years ago.
It was a withhold as well, Your Honor.
All right. So I'm not going to drug test you. Don't make me a liar, Mr. McCoy. All right? Have a great day. Huh? Straight PTR. No drugs, no alcohol. So just make your beats. Don't don't do all the other nonsense that goes on in studios. All right?
Absolutely.
All right, have a great day. All right. Good afternoon, sir. Can you tell me your name?
Good. My name is Mendez Joshua. Very responsible.
Joshua Mendez.
Yes.
All right, Mr. Mendez, you're here in 2021 CF 6554 AL on charge of burglary of an occupied structure and petty theft. Did review the charging affidavit in this case. Did find probable cause for your arrest. Going to stay your bond in this case amount of $5,000 as account one, $100 as account two. Additionally, your bond, you're not allowed to return to the scene of the location where this incident happened. You may not have any contact with any victims or witnesses. You may not possess or consume any drugs or alcohol without a valid prescription. I'm going to appoint the public defender to represent you in this case. You have a great day, sir.
Can I have one more question?
Uh,
Representing myself?
You want to represent yourself?
Yes.
All right, now I won't appoint a public defender to represent you, but you need to have a full hearing about that with your judge. When you get to court, you talk to your judge and tell you want a FREDA hearing.
Okay, could you appoint me a lawyer then? Appoint me a lawyer.
Which one do you want? You want to represent yourself, or you want me to appoint a public defender to represent you?
A public defender to represent.
All right, I'll appoint a public defender to represent you, because you qualify. All right, have a great day. I had Muniz bonded. All right.
Antoine Neal, Your Honor?
Muniz. First name Eric Muniz.
Okay.
All right, I have Mr. Neal. I'm guessing this is. Good afternoon, sir. Can you tell me your name?
Antoine Neal, sir.
Mr. Neal, you're here in case 2021 CF 6543 AO for a charge of destruction of evidence. They reviewed the charging affidavit in this case, did find probable cause for your arrest. Going to set your bond in this case amount of $500. Condition on your bond that you not possess or consume any drugs or alcohol without a valid prescription. Going to appoint the public defender to represent you in this case. You have a great day, sir.
Yeah, I'm trying to understand. I'm out of here. You said how much is the bond, young?
500.
500. Okay.
Yes, sir.
Thank you, sir. You have a blessed day.
Yep, you too. All right. It's Friday here. What? This is an interesting Friday. Yes. Good afternoon, ma'am. Can you tell me your name?
Nidia Alexi, Janire, Oppenheimer, Ramos.
Ms. Oppenheimer. All right. Ms. Oppenheimer, you're here in case 2020 MM 676 AO for failure to appear. The judge in that case set your bond amount of $5,000. You're also here in case 2020 MM 1911 AO for failure to appear. The judge in that case set your bond amount of $5,000. You're also here in case 2020 CF 6278 AO for a failure to appear warrant. The judge in that case set your bond amount of $0. You're also here in case 2020 CF 6832 AO for another failure to appear warrant. The judge in that case set your bond amount of $10,000 on count 1 and $500 on count 2.
$500, Your Honor?
I think it's 500, correct?
It's 10,500.
I spoke with Ms.
Once-
Oppenheimer, I believe in the back, that these are unattainable to Ms. Oppenheimer, the totality of these bonds.
Well, the law doesn't allow me to change these bonds without speaking to the judge that sent you, that wrote these warrants or ordered these warrants. So you gotta take it over to your division judge. You can file a bond motion in front of those various judges and see if you can find an amount of money to allow you back out on.
I had the money for me to bond, out. I just need the one that said no bond. I need a,
So we gotta talk to that judge about that warrant,
apologize.
all right?
Don't know, all right?
Good afternoon, sir. Can you tell me your name?
Ruiz.
I can't hear you.
Gabriel Ruiz.
Mr. Ruiz, you're here in case 2020 CF 129652 AO for a failure to appear warrant. The judge in that case set your bond amount of $2,000 on count 1, $300 on count 2, and $300 on count 3. Your bond's going to remain as set in that case. I think you're already appointed the public defender, correct? So if you want to bond out, you can bond out or get in front of your division judge to have a bond hearing. All right, have a great day, sir. All right, can you tell me your name, sir?
Robert Shirk.
Mr. Shirk, you're here in 2020 CF 14894 AO for a failure to appear warrant. The judge signing your warrant set your bond at $0. Your bond's going to remain at $0. We're going to get you in front of your division judge if you want to have a bond hearing to be released. I think you're already appointed the public defender, so have a great day, sir.
When will it be?
You got to talk to your attorney in that division. Can you tell me your name, sir? Good afternoon.
Good afternoon.
Can you tell me your name?
Giovanni Angelo Williams.
Mr. Williams, you're here in case 2020 CF 11379 AO for a failure to appear. The judge signing that warrant set your bond at $0. I believe you're already appointed the public defender, so you need to go talk to that division judge if you want to be released out on bond. Have a great day, sir. All right. Good afternoon, sir. Can you tell me your name?
Harvard Williams.
Mr. Williams, you're here in case 2021 CF 6569 AO for a warrant on a charge of sale and delivery of methamphetamine. The judge already found probable cause for your arrest as to that charge. Going to set your bond in that case amount of $15,000. Condition of your bond that you not possess or consume any drugs or alcohol without a valid prescription. You may not associate with any known drug users or drug dealers. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. When this incident allegedly happened, you were out on bond in case 2021 MM 3492 AO. Of course, we're going to revoke that bond. Set a new bond at $0. And my no contact order in that case is still in place. You're still ordered to have no contact with the victim even while you're here at the Orange County Jail. Good afternoon, ma'am. Can you tell me your name?
Chanelda Zenobia Williams.
Ms. Williams, you're here in case 2021 CF 6549AO on charge of battery, one prior battery conviction. I reviewed the charging affidavit in this case. I did find probable cause for your arrest. I'm going to stay your bond in this case amount of $2,500. Condition of the bond that you had no contact with the victim in this case. Not return to the scene of the location where this incident happened. You may not possess or consume any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. I'm going to appoint the public defender to represent you in this matter. You are out on bond in 2020 CF 1280AO. In that case, the court's going to revoke that bond. When I set a new bond is $0 in that case. I believe you're already appointed the public defender in that case.
She is the sole provider for her child. I believe the two cases are different victims. If you're going to revoke the bond, I would have you set a different bond amount as opposed to setting a none.
Well, first question.
Due to the child carrying responsibilities of Ms. Williams.
All right, where are all the children and who's taking care of them?
Right now, they're at my grandma's, but she just got out the hospital from an accident, and she's not able to do
Right.
nothing. They're just,
And where's the child or children's father?
they don't have a father. My son's father's deceased, and then, the other father moved out to Georgia, so I have no contact with him at all.
Your Honor, she was out on bond for a felony battery and picked up a new felony battery.
Yeah.
I understand the charges, Your Honor. It's just.
Well, my concern, I'm not going to give her a bond. My concern now is where are the children going to be? Do I need to contact DCF? Do we need to take some action to make sure the children are going to be sheltered properly and taken care of while Ms. Williams takes care of this case?
Your Honor, state would also ask for the condition of no weapons or firearms.
All right.
Your Honor, I believe the grandma can't take care of the children. She's a working adult. And as she mentioned, out of the hospital, she's requesting a higher monetary bound on the out on bond case. She is the sole caregiver of the children. Other than that, I don't know who else can take care of them.
Well,
Says no one else can take care of them except.
Well, we have systems in place to make sure that that's done. That's what I'm trying to, figure out is whether that we need to call the hotline. We need to have somebody go check on the children, make sure there's a plan in place for the children, possibly find the father of one of these children because he has a legal responsibility to take care of that child. So do we need to activate that system or was his grandma going to be okay for the next few weeks while Ms. Williams is taken care of?
She said that she will speak with grandma, taking care of the children for a few weeks while she deals with these issues. She'll be in contact with our office to deal with any bond conditions as well, and to hopefully perhaps
Well, if it
resolve
becomes
these
an issue-
cases sooner rather than later.
Yeah, if it becomes an issue, you need to raise it with the judge in your division to make sure that the children are provided for and that, we had those social systems in place for that reason. All right. Have a great day, ma'am.
You too.
All right, tell me your name, sir.
Victor Manuel Calero.
Is there Calderon Matos?
That's my mother's last name.
Is Calderon, Calderon is your?
Calderon.
Is Calderon? Okay, just asking.
Calderon Matos. It's Calderon. I don't know
Okay.
why they put my mom's last name there.
Tradition.
Well, mixed up in the States.
Yeah. All right, Mr. Calderon, you're here in case 2010 MM 3386 AL for failure to appear. Judge, in that case, set your bond amount of $1,000 on count one, $3,000 on count two. You're also here in 2010 CT 3596 AL for a failure to appear warrant. Judge, in that case, set your bond amount of $2,000. You're also here in 1999 CF 8716 AO for violation of probation. Judge, in that case, set your bond amount of $0. You're a violent felony offender of special concern, sir. You're not entitled to release on that violation of probation case until your violation of probation is completed. I'm going to appoint the public defender to represent you in all your cases. You have a great day, sir. Good afternoon, ma'am. Can you tell me your name?
Amy Santiago.
Ms. Santiago, you're here in case 2018 CF 8796 AO for violation of probation. The judge signed your warrant in that case, sets your bond at $0. You're a violent felony offender of special concern, ma'am. You're not going to be entitled to release on the violation of probation until your case is completed. You're also here in 2020 CT 1516 AO for a failure to appear warrant. The judge in that case set your bond amount of $1,000. Going to appoint a public defender to represent you in all your cases. You have a great day, ma'am. Good afternoon, sir. Can you tell me your name?
Jeremy Jamal Smith.
Mr. Smith, you are here in case 2020 CF 10245 AO for violation of probation. Based on on-view affidavit, your bond is going to be set at $0. Your bond's going to remain at $0 until we can get you in front of your division judge to have a bond hearing. I'm going to appoint a public defender to represent you in this case. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Kevin Bell.
Mr. Bell, you're here in a Palm Beach County case for 2020. Is it 2020? Oh, sorry, yeah, 2000 or maybe 2000. 2002 or 2000? I think it's 2000. CF 2851 AO for violation of probation from Palm Beach County. The judge in that case set your bond at $0. Sir, you're a violent felony offender of special concern. You're not going to be entitled to release on this violation of probation case until your violation of probation is completed. I want to appoint a public defender to represent you until we get you down there to Palm Beach County. You have a great day, sir.
Your Honor, I believe it's 20 CF 2851 to 2020.
2020? Or is it, so it's 2020 CF
And then it's
2851?
002851.
All right, so 2020 CF 2851, Palm Beach County. Have a great day, sir. Tell me your name, sir.
Christopher Escalera Rodriguez.
Sir, you're here for a Volusia County case. The judge in that case set your total bond amount of $50,000. It was $100,000 on each count. I'm going to appoint a public defender to represent you in this case until we can get you over to Volusia County. You have a great day, sir.
You said it was 100,000 on each count?
No, 50,000, 10,000 on each count.
10, okay.
All right. All right, good afternoon, sir. Can you tell me your name?
Matthew Ize.
Let me show you all your cases here. All right, so this is just out of county. Mr. Ize, you're here for an out-of-county warrant in 2021 CF 1332 from Seminole County. The judge in that case in counts 1 and 2 set your bond amount of $3,000 on each count, and count 3 is $500. You can post that bond if you would like. We'll get you on to Seminole County as soon as we can. Have a great day, sir. Going to appoint the public defender to represent him until that happens. Can you tell me, good afternoon, sir, can you tell me your name?
Huggins,
What's your full name?
Stuart Huggins.
Mr. Huggins, you're here in case 2020 CF 571 from Hillsborough County. The judge in Hillsborough County set your bond at none on this violation of probation warrant. Hopefully we can get you on to Hillsborough County as soon as we can. We're going to appoint a public defender to represent you until that happens. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Michael Scott Richards.
Mr. Richards, you're here in several cases from St. Johns County. The first one is 2020 CF 803. The next one is 2020 CF 1097. And the last one is 2020 CF 63. In all those cases, the judge in St. Johns County set your bond at $0. Your bond's going to remain at $0 and we get you up to St. Johns County. I want to appoint the public defender to represent you while you're here in my custody. Have a great day, sir. No? Creole, did they ever email you? Let's call and see where I got. I was calling to see if we got a Creole, somebody knows.
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I've been previously sworn.
Good afternoon, Mr. Barrera. I have a question for you. Do you know if the Creole interpreter is available for us this afternoon by any chance?
Your Honor, I'm not able to answer that for you, but I can have someone in my office, or if you just want to hang on a second, I can reach out to my either our administrative person or one of my colleagues. I don't have that information personally, but I can track it down for you if you give me a moment.
Yes, sir, if you could.
All right. Thank you, Your Honor. Your Honor, I just spoke to our administrative assistant, the person that's our scheduler, the person that deals with the freelance interpreters, and unfortunately, we do not have one available at this time, Your Honor.
All right. Well, thank you very much. Have a great weekend.
You as well, Your Honor. Thank you.
Your Honor, can I ask Mr. Never mind, Your Honor.
Good afternoon.
Hello, good afternoon.
Can you put your name and your ID number on the record?
My name is Tuis. My number is 111546.
All right. Can you raise your right hand and be sworn in?
Yes, Your Honor.
Do you solemnly swear or affirm you'll translate from English to Creole and Creole to English to the best of your abilities, so help you God?
Yes, Your Honor.
All right. Ma'am, I need your help with a defendant at my lectern. Could you have him tell me his name?
Allô, bonjour. Moi, relé Thérèse. Moi-même, c'est interprète là. Qui non, comment relé?
Moi, c'est Gardens.
M'attendez ou non?
Gardens Via.
Garden Vieja?
Gardens Via.
Jordan Vieja.
Gardens Via.
Oh, Gardens.
Via.
Vieja.
Sir, you're here on two cases. The first one is 2021 MM 3794AO for the charge of battery.
I'm sorry. Can you repeat 21 mm? I'm sorry, sir.
3794AO.
794 EU. OK, monsieur Oulana, deux charges. Première, c'est de 21 MM 37944 A. Et 4 EU.
You're also here in case 2021 CF 6548AO.
Expire 48 EU. OK, ou là encore pour 2021 Fiat qui expiré à 48 EU. Fiat.
The charge in that case is aggravated assault with a weapon.
Charge là c'est aggravé assault avec zam.
I did find probable cause for your arrest as to these two cases.
OK, moi ouais bien cause pour yo capable arrêter ou parce que moi deux cases.
We're going to set your bond in the misdemeanor case in amount of $500.
OK, moi pour faire une caution pour misdemeanor, yon ti crime qui comprend payer 500 pour $500. Yon ti offense pour $500.
I'm going to stay your bond in the felony case in amount of $2,500.
Felony, 2,500. Felony, case felony qui veut dire crime, c'est au coup pour capable payer $2,500 pour ça.
Conditions of your release for both cases. You have no contact with the victim.
Donc, pour tous les deux questions, pas supposé bien contact avec victime.
You to maintain a separate
Tous les deux victimes.
you to maintain a separate residence from the victim.
I'm sorry, Your Honor?
He is to maintain a separate residence from the victim.
Oh. Ou supposé rester, nous supposé rester séparés, nous pas supposé rester même côté. Séparés, nous supposé séparés.
I will give you a one-time return with law enforcement to retrieve your personal items from the residence.
OK, ma bon pour capable retourner avec yon police pour capable point à faire ou nan kay la.
May Madam Interpreter inform him that if he talks about the facts of the case, that it may be used against him later, everything's recorded?
OK, so n'importe ça ou dit capable d'utiliser contre vous parce que qu'on y a toute bagay qui là a recordé toute bagay a recordé.
You may not possess any weapons or firearms.
Ou pas supposé gen zam, ou pas supposé gen bagay pour zam à feu, ou pas supposé gen zam ni zam à feu.
Any weapons or firearms that you have in your possession need to be turned over to law enforcement within 24 hours of your release.
OK, n'importe zam qui gen à feu, n'importe zam qu'on y a là, ou supposé retourner ni dans l'état dans 24 heures après au voyo aller. yo kito ale.
I'm going to appoint the public defender to represent you in this case.
Mwen ble aponte a public defendant la ka represente ou nan kes la.
You have a great day, sir.
Pase bonne journée, monsieur.
S'il te plaît, m'ka pose une question?
Please, can I ask a question?
Ok. Mwen jist, mwen la mba menm kon pou ki sa m la. Se on chemise mwen te so presse pou mwen voyaje pou ma joun papa. Mwen te nan kay la, mwen te enferme yon chambre kay. Et puis, mwen kob mwen fini m pap travay, m fe 8 mois m pap travay, koun ya papa m voy yon ticket, achete yon ticket pou move, pou m'ale. Koun ya mani paret, mwen dam nan kampe nan papot lan. Et puis, mwen di, excusez nou.
Fonti tan mwen, s'il vous plaît. Fonti tan mwen baka di tout bay à la fois. Okay, so Your Honor, I just told him now to give me a portion, so I translate, and then he continue because I don't want him to give me too much at the time, so it would be difficult for me to translate it accurately.
So, what's the question? I guess you have a question for me?
Yeah. He was saying that I'm here. I don't know why I'm here. So there was a shot that I was going to press so I can go. I can go travel to see my father. I haven't been working for 8 months, and I came home. I saw the lady in front of the door. Okay, he was continue talking, so I stopped him from there.
All right, well, as the reason why you're here is the allegation that you struck or tried to cause bodily harm to a victim, and that you threatened a victim with a weapon. That's the charges that you're facing.
Okay, ou là, c'est parce que ou te vle cause ou te vle ba moun problème que yon victime que ou menacer moun nan avec zam ou menacer moun nan avec zam. C'est pour raison ça qui faut là.
Okay.
Whether that's true or not is not for me to decide today.
Okay.
Même si c'est vérité ou pas, c'est pas moi qui pour décider ça aujourd'hui, c'est pas pour moi pour décider ça aujourd'hui.
I appointed you an attorney to assist you in understanding your facts of your case and for you to have representation in this matter.
OK, moi appointé yon avocat qui comprend tout problème yo, qui pour aider ou qui pour assister ou dans problème ça, qui pour représenter ou dans problème ça.
I need you to call the number that's on that green sheet of paper that's in front of you. They should be able to provide you with a Creole interpreter or possibly a Creole attorney for you to speak with.
OK, moi vle pour capable relé numéro ça dans gay vert ça, relé numéro ça, puis yo capable bon yon interprète ou bien puis yo capable bon yon avocat qui parle créole qui capable aider ou.
All right, have a great day, sir.
Passez bonne journée, monsieur.
Okay, merci.
Okay, thank you.
Thank you, Madam Interpreter.
You're welcome, Your Honor. Is there anything else I can do for you?